11 matter, my lord, appearing your single bench and the assigned matter. Report number 655. Well, long month is pending, my lord. Lordship can. And what the bench will Lordship can fix one day, my lord, in a week, and last day of the week. Lordship, they are about 1 year, my lord, pending. Lordship kindly consider it.
Lord, may I have your lordship's kindly?
1/2 in a week. One.
Yes.
May I have your lordship's kindly to mention an application for inclusion in connection with the Group 6 appeal?
My lord, permit me to mention a matter for inclusion is hearing.
Give.
Sir. Sir, I am Sunil Pain, ex-Panchayat Pradhan. I entitled from leave 2025 সালের 24 নভেম্বর এটা কনসাইনমেন্ট অর্ডার হয়েছে। তারপরে আমার অ্যাডভোকেট বারবার মেনশন করছেন, কিন্তু কোর্টে কেসটা আসছে না। WPST 224/2013 with connected application.
Lord, perhaps these matters have been assigned to this bench, my lord. Required, my lord. It's mentioning for
He is appearing in person. Oh, send your lawyer.
বারবার মেনশন করছেন।
You send him. Yes.
To have an urgent mentioning, I'm being led by Mr. Sen. He's mentioning online. My lord will kindly allow.
Yes, Mr. Sen.
That application once again, my lord, your lordship had given me leave to come back on Monday.
Yes.
So, but I'm sorry, I'm mentioning online, my lord. But I
Mention or appear online, you are more than welcome to mention or appear online.
yes, I'm obliged, my lord. But only thing, my lord, as I told your lordship, my lord, this is a very
All right.
somewhat peculiar matter, my lord. The matter was withdrawn on the basis of a written instruction. Thereafter, my lord, on fresh, my lord, advice, they say, my lord, that it should not have been withdrawn because, my lord, this is the appeal is the only remedy, my lord. But
on Thursday.
It will come on 23rd.
My lord, I appear for the respondent.
Oh, you are appearing.
Yes, my lord. My lord, this is, my lord, otherwise an infractious application. There is no urgency in this, my lord. They have only
my
waited.
learned friend can have his say when the matter appears and it can be dismissed. So, my lord, I don't think, my lord.
Yes, my lord, this matter has only been mentioned after this matter, my lord. The main appeal has been posted for hearing, my lord. My lord, I am opposing this, my lord, fixing, my lord.
So you want that it should remain pending for all times to come?
My lord,
We are listening. We don't know what will happen.
Right.
Yes, 23rd. If there is some date next week, this week, which is more convenient, you can tell us, or we are fixing it on 23rd.
Right.
Yes. Yes.
Obliged, Lord. Very much obliged, but
mentioning slip.
Mentioning slip.
23rd, if we don't have a 2 p.m. matter, we can fix it at 2 p.m. Just see. Just give us a minute, please.
yes, Lord.
Order telling.
See, we can't keep it pending for us. Let's see. One matter we have, so we'll keep it at 2 p.m. Let's see.
Yes, we shall be there. Obliged, Lord. Very good.
Number one. Item number 1, my lord, I appeal for the petitioner. In terms of the lordship, last election, my lord, I have served the copy of the miscellaneous application for condonation of delay to my learned senior friend, my lord, and this is for your lordship, my lord.
Where is that?
My lord, I have already handed over to my learned senior friend, my lord. This is for your lordship, my lord.
দুইটা দাও, দুইয়ের মধ্যে বোধহয় ওটা আছে।
My lord, in the miscellaneous application, 2 points were taken by the petitioner. The one is with regard to COVID pandemic, which was there. And my lord, there is a order of the Honorable Supreme Court that limitation won't run till 28th of February 2022. And the other point was taken, my lord, his parents, my lord, ailments. The series of medical prescription have been annexed with the condonation application, my lord.
You have served a copy.
Yes, my lord. I meant to it, sir.
এই তো এটা হয়ে গেলে লাস্ট অর্ডার শিট প্রিন্ট ফানিশ না 13/9/24 কোন কোর্টে আমাদের স্যারের সঙ্গে তলায় ডেটটা আর বেঞ্চটা লিখে দেন
The penalty 22 to 21 is impugned. So there is no final adjudication by the tribunal.
No, my lord, with regard to this, so there is no final adjudication.
It is just pending.
Yes, my lord, skip pending, my lord.
There is an order already condoning the delay.
Absolutely, my lord.
Why did
Order
we-
dated, my lord.
Yes, we have seen that. 4/3/25.
25.
Yes. So there is no appeal.
No, my lord, against this condonation, my lord, allowing the condonation, my lord.
No, against the order of the dismissal.
No, my lord, there is no appeal, my lord. I have learned, my lord, my lord, last Wednesday, your lordship was looking into that rule. My lord, your lordship was looked into the rule of 71, but there was an amendment in 2008. My lord, where, my lord, it's in parameteria with the, my lord, initially, my lord, in 71 rules, the parent rule, my lord, there is a provision for appeal to the governor as a person of designator. My lord, that rule has been amended in 2008 amendment. Now there is nothing, my lord, which says, my lord, with regard to the amending provision of, my lord, making an appeal before the governor.
Revision is there only.
Revision is there, your lordship has seen that revision is there. My lord, your lordship knows, my lord, it also says with regard to revision, my lord, if I'm not wrong, it says after the period of appeal or otherwise, your lordship has taken the word or otherwise. Well, I was here also, my lord. But this otherwise may have some consequence on me, my lord, I accept this part. But, my lord, I have not preferred a revision, my lord, I have proceeded on it favorably.
That was peculiar to that facts in that case.
This one. That was one officer, my lord, making some Facebook comments or something, my lord, your lordship was
Yes,
hearing it.
He was a deputy collector, if you remember correctly.
Yes, my lord. He had made certain posts and his contention was, I have a right to make a post after this was his contention, my lord.
He was saying that he has a personal right to expression and that need not cast a shadow on his official duty.
Absolutely.
It is not in discharge of official duty, therefore it cannot constitute a ground for misconduct.
Absolutely. This
That was his case.
Absolutely, my lord.
But Lordship, here the facts are different.
What is the fact? What is the
The
issue?
fact is, my lord, the petitioner before lordship, my lord, was, my lord, before coming into job, my lord, he was, my lord, there was a criminal case lodged against him. My lord, while the criminal case was pending, my lord, he was selected for a post of general duty medical officer. My lord, when the PVR was served, my lord, he was not served with a charge sheet, or he doesn't have any information of the charge sheet has been filed before the London Criminal Court or not. My lord, this was,
You were on bail.
I am on bail, my lord, court bail. My lord, on 27th of January, the Honorable,
The only issue, if we remember correctly, we had raised on the last occasion is when a party is represented by a learned advocate, can he feign ignorance of anything that is going on in the court?
so, my lord, this is your lordship's query, my lord.
Where is the proceedings, Lordship?
Because you were on court bail, you were represented through an advocate. Thereafter, the charge memo was submitted. It was adjourned. On the next day, it was served on you, as we remember. Now, can you say that till that date I did not know about the charge?
My lord,
Information slip does the work.
my lord, subject to lordship, kindly, my lord. What happens, my lord, just Vishash may be knowing better than any of us, my lord, he has dealt with these sort of matters in.
No, that's not the issue. The issue is the order records that the charge sheet is being filed. And on the next day, it was served on you. That day, you were not present. But since you are represented through an advocate, can you say, I don't know what happened in that day?
My lord, normally what happens, my lord, as I've been told, my lord, I do not normally go to the lower courts. What happens, my lord, when the charge sheet is filed before the judge. Not, my lord, it is an open court, and order is passed, or it will be listed in it.
No, in this case, there is an order.
It's an order, this order is.
Therefore, we are saying that's not an issue here. Here, there is an order
Yes, my lord.
that the charge sheet is being filed.
Yes, my
But
lord.
then it is not served on you and it is adjourned. On the next day, it is served on you. So therefore, can you say that I did not know?
Lordship, prior
If your lordship sees the order, sorry, lordship, kindly.
Yes.
I'm reading out the order.
Page?
My lord, that is 47, 47.
Yeah. Yes.
My lord, your lordship sees second order.
Yes.
57, 115. Receive charge sheet number such and such under section such and such against one accused named such and such, along with the Xerox copy of the, my lord, some papers, Xerox copy of police papers, cognizance taken after perusing the CS and the relevant documents under section 173 of the CRPC and kept in the CR with the court record. Accused is in CB. But this is what is mentioned. It never mentioned, my lord, presence of any of the advocates or any other thing, my
not
lord.
meant to
It is
be.
only with the learned court in its, my lord, I may say in its chamber it is done. It's not in the open court, it's taken out, my lord.
Lordship, prior to filling up forms,
And
Lordship.
what is the date on which you submitted the PVR?
My lord, on my lord, 11th of May, 2015.
11th of May.
May, my lord.
6th of May.
6th of May, there is
of May.
11th of May.
Lordship,
6th of May I have signed and my lord, it was notarized.
normally what is done, we check the records, take an inspection slip and then on the basis of that inspection, the PVR is filled up. So he doesn't have to be present, I mean, be served with a charge sheet. This explanation is not correct, Lordship. Charge sheet is filed by the police after completion of investigation. But then prior to filling up any form which requires the details of a police case, he knows there is a police case. A simple inspection slip from the court would have been enough to provide the details, Lordship.
My lord, if your lordship takes up page 47, first order, 2710. OP accused is on court bail in file Hajira.
Next date.
My lord, that day, my advocate was present. Next, my lord, the next day when the charge sheet was received and cognizance was taken, that is in the chambers of the learned judge, my lord, and not, my lord, in the courts.
That we can't say from looking at the record whether it was in the chamber or it was in the court. That is neither here nor there. This is an order sheet.
Yes, lord.
You
My lord,
can't
your
read
lordship
that
says-
it was in court or it was in
It
open.
cannot be.
My lord, if your lordship takes 3 orders, page 47, first order,
Whatever it is,
the-
there is no way to come to a conclusion based on the record that any order in this order sheet on this page
Yes.
was passed in a chamber and not in court.
I mean, I understand, my lord, it never says.
Therefore,
Lordship,
no, it does. There are times when the court may say it is taken up in the chambers. There are such orders also. It cannot be passed in chamber, we agree.
Not.
Cannot be. And we cannot take it that far. We cannot read into the order something which is not there, which is not manifest from the record.
My lord, at least, my lord, subject lordship kind leave. What I get 3 orders, page 47. The first OP accused is on court bail and file Hajira. So, my lord, that day undisputedly the advocate must be there to file in Hajira. My lord, next order doesn't say about any Hajira. Third order doesn't say anything about Hajira. The fourth order, the day I received the charge memo, it says, my lord, CS submitted under section such and such against.
We are not on that, sir. We asked you the last day. Today also, with the first query we made from you is that when you are duly represented through an advocate,
Yes, my lord.
can you claim an ignorance of any order passed in the proceeding when you have not questioned the state of affairs for at least 2 years, if not more? You have not questioned that state of affairs knowing the consequence for at least 2 years.
Yes, my lord. That I cannot improve, my lord, which is not there, my lord, I cannot improve, my lord.
That is the issue. And if this is the situation, then your second case
If I lose this 1 second, my lord, I don't.
has to
that-
collapse.
That should collapse. My lord. I'm not disputing that. If I succeed here, then there's a glimmer of hope.
Hmm.
If I fail here, no hope.
Because the order in this case of dismissal is of 21.
Yes, my lord.
When this dismissal order formed the basis of your dismissal in the second employment, when you challenge
Yes,
this.
that.
That's true, my lord.
Till this date, till the date of the second order, you had not challenged it.
That's true, my lord. I cannot improve my case, my lord.
The COVID and all this is nothing. Why after that order? What have you said in the MA regarding that? How have you tried to club it with the subsequent dismissal? That we didn't find from the EMA.
No, it's not there, my lord. Which is not,
Not
there,
there,
I cannot
yes.
say it's there. But I cannot make out something which is not there before the learned tribunal and make it
Exactly.
before lordship, my lord.
We knew that as a result of this PDR, you were dismissed. Now, how, and in the next case, what is the declaration?
The declaration says, my lord, I am being, reasons for leaving the earlier job, it says, my lord,
Disciplinary
disciplinary
proceedings.
proceeding. It's there, my lord. My lord, if I, subject lordship leave, my lord, if I fail here, second case, your lordship may not be opening it. That dismissal orders sharing it my face, my lord, that, my lord, forfeits my any service with the government after the dismissal order.
Let us see, where is the order in the second case? 210.
Yes. That is page 109.
109.
9. I know what it clue.
And where is the declaration in that second case? Which page?
My lord, I have also
2.
102, my lord. Also, I filed one supplementary, my lord. 102, column 13. I column 12, my lord.
12.
Column 12.
My lord, 12. It says, my lord, Para BPHC, Para Purulia, due to departmental proceeding.
What does it say? Para?
My lord, Para BPHC, my lord, Block Primary Health Center, is in the district of Purulia, due to departmental
That's
proceeding.
the place of posting.
Yes, ma'am.
That
That was the place of an earlier
that was where
posting.
he was working previously.
In both cases, no order has been passed by the tribunal yet.
No, my lord. Initially, it was admitted, my lord, after condemnation of delay, my lord, the direction to file reply and every other thing, my lord, thereafter the tribunal become dysfunctional, non-functional. Putting this जाके आराम ज्यादा no, ठीक है, so mention
WPSC filed in 24, 25, both,
my lord, these were of my lord
22.
2025,
Lordship,
both in 25.
both in 25, my lord. And this original application is of 24, both are of 2024.
Hmm?
The original applications are of 2024.
24.
After the tribunal
After-
became
after-
non-functional, I approach your lordship, my lord. Not prior to that.
Of 24,
The original applications of 2024, my lord.
can you give us the date from the way?
24. 667 of 24.
Is the date available anywhere? Because the dismissal order is of 9/12/24.
Yes, for the second original application.
Yes. So you filed it within what? Within a week from dismissal?
My lord, it's the fag end, my lord. I have to check, my lord. But it must be in the fag end of 2024. It has been filed. It must be in the month of December, or else my lord, 2024 number would have not been there, and dismissal order could not have been annexed with the original application. Copy file হয়েছিল কবে?
The date is not here.
Date নেই। Verification করে দেখো, আছে date আছে।
Verification page.
কত করে দেখি date নেই দেখি।
Yes, you are relying upon some judgments.
No, my lord, it's only factual thing I can say, my lord.
Heard the learned advocate for the
Last Friday, when the matter was called on last Friday, my lord, I was in online mode. I could not enter. The moment I enter, your lordship is asking Mr. Bishop what happened. There is no one here.
Yes.
Couldn't enter because of some technical reasons, my lord. For that day, I could have been done, my lord.
No, that day there was very thin attendance
Very thin.
for quite some time in the first half.
After Rath Yatra, my lord, everybody was taking a good
There
nap,
was
my lord.
Somehow there
Is it?
huge
Because the
traffic jam, lordship. For what reason, we don't know. I mean, it's from a huge distance, actually. The
And
reason we couldn't
tomorrow
find
will be the
out.
same, my lord. I don't know, my lord. There's three scattered. I've been told three scattered. 21st July celebration would be taken out. Celebration, whatever is there, taken out. Tomorrow, my lord, there will be some again. This May.
oh, acha, yes, I remember from last year.
Yes, lord, your lordship was fixed for what I said, not on 21st. Then your lordship, why 21st?
So it will. You are expecting it this year also.
My lord,
Maybe
there is three,
to
my lord,
that extent,
may not be
but
that extent, but three
scattered,
we
there are
might be
three
road might be
factors,
blocked.
three places.
Oh,
So tomorrow we might expect a jam.
Tomorrow there might be some traffic congestion.
let's see.
Point number 3.
Replay this one, please. সময় করে দিতে হবে। আমার iPad
I'm for the petitioner, my lord. My lord, supplementary affidavit.
মানে তো রোগা তোমাদেরটা তো মোটা কেন?
Your lordships on the last occasion directed, my lord, that we must file a supplementary affidavit and we must put it on record that what are the proceedings that have been initiated by my client, my lord, before the tribunal. My lord, we are armed with this paper, certified copies were applied for and copies served, right?
Supplementary to legible.
Legible.
It's small legible. Petitioner গুলো পড়া যাচ্ছিল না, এটা হচ্ছে ঠিক আছে না, ওটাই বরঞ্চ legible.
অনেক কাগজ তো।
Petitioner গুলো পড়তেই পারছিলাম না, বরঞ্চ সাপ্লিমেন্টারিটা legible. আছে আমাদের
কোন অর্ডার গুলো চ্যালেঞ্জ করেছেন কেটে
লিটল
সেটের অর্ডার চ্যালেঞ্জ করেছেন
রাত 12টা। এটা লিস্টটা দেখি তো কোনটা আগে কোনটা পরে। 12 আগে, এটা 3, 12টা 3।
Yes, Milord, I was appointed as ex-management doctor of the erstwhile Chittaranjan National Cancer Institute, Milord, which was initially a trust, Milord, on 1/1/73. Disposed of on 16/5/2023.
Where is it?
16/5/2023, OS 706 of 2022.
Where is it?
ওটা বুঝতে
The next original application certified copy,
No, we have it at page 49.
6/15/2023 order. The matter is taken up by the single bench pursuant to the order contained in notification dated such and such, issued in exercise of the power conferred under section 5 subsection 6 of the Administrative Tribunal Act on consent of the learned counsel for the contesting parties. The case is taken up for consideration sitting singly. The issue in this application is for a direction to the respect to convert his provident fund into CPF into General Provident Fund. In terms of the tribunal's order, the respondent Director of Health Services passed a rescind order on 4th March 2021, which was communicated to the applicant also. In the operative part of the order, the respondent advised the Director General such and such Ayurvedic Medical College to proceed for converting the applicant's contributory provident fund into the general provident fund amount and disburse his pensionary benefits. During today's hearing, Mr. G.P. Banerjee, learned counsel for the state, files a files a copy of the correspondence dated 7 February 2023, addressed by the Principal Superintendent such and such hospital to the applicant, Dr. Subhash Chandra De, that is now petition of worship. It is stated that the applicant has been requested to provide details of CPD statement as examined doctor at Chittaranjan National Cancer Institute. Hospital. Submission submission and council sites and satisfied. Disposed of.
You challenge this order.
Now it's been done.
Yes,
You challenge it.
yes.
Where? In which rate petition?
Next writ petition. Next writ petition. Item 4.
The same
Huh?
date.
Item 4 of your lordship's list.
Lordship.
There is another rate
There are
petition.
2 writ petitions, Lordship. Come on the
So then why this writ petition has?
This is WPST. I'm questioning the paragraph 15 of this, of your lordship's brief.
Hmm?
14 and 15. I am just from lordship's consideration of the 16 from 23. I can move stated in paragraph Senate application to WPST 3 of 25 that the petition states that same petition is taken for consideration 16 from 0.
We are asking you a different thing. We are asking why 2 writ petitions have been filed. If you, unless the order of 16/5/23 was set aside, where was the occasion for you to embark on another exercise?
That is a mistake on our part. That is what I have said on the last occasion. That is why your lordships were of the opinion that my submission must tally with the records. Records were incomplete. That is why I was directed to produce the entire sets. How many applications I filed? Why did I file? Here, Miller, the case is what? Miller, I have completed, Miller, only 2 minutes. I completed 34 years, 19 days in the service. Continuity of service was there. I have, Miller, filed an application if I was absorbed in the government service. My 19 years in service was calculated, but the rest 15 years was not calculated. The
So the second writ petition need not proceed. It is a pointless exercise. If you succeed in the first, you succeed.
I have filed, Miller, 3OA.
You seem to be having a lot of it. All this seems to be luxurious litigation. What is this? This is the way. You tell us.
I
Expected from anyone.
Miller, I humbly submit and bow down to Miller's observation. But here a doctor, Miller, had rendered service.
Whatever it is, this is not the way. That's not the issue. What he has done, not done, is comes later. Just see.
No, whether
Every day is filing an way. Every day is filing a writ petition.
no, Miller, here
What
Miller,
kind of doctor?
no,
what
it
kind
is-
of service he has rendered? We
that
need
is
not
Miller,
say.
Miller, I said
We are not going to go into what kind of service he has rendered.
No.
But look at it.
But ultimately, because your lordships are here, my lord, many a times your lordship have said that we are here to unravel the truth. To unearth the truth, my lord, is this, that a person, my lord, was allowed to, my lord, render his service
The
34
fact
years.
remains that
We-
we are
it is a
here
very
to
simple
look into,
process.
we are here to look into bona fide litigation.
Yes, there is,
not
there is,
litigious
there is
litigation.
there is no, with deepest respect and humility, this doctor, he had filed the disposition, there was a mistake of fact by parties in the proceeding. State had also, my lord,
We are not on that. Why
No,
the second?
why, my lord,
We are only on why
Sir,
second.
because, my lord, I tell your lordship, on the last day also, it is not possible for your lordship to remember everything. I said, my lord, that both the lawyers were under impression, including the petitioner, that he had to submit, my lord, contributory provident fund. Fact remains there is no contributory provident fund so far as he is concerned, they are not apply. On that premise, my lord, he continued the two litigations.
Why the second rate petition for the same relief? Verbatim same relief. We have just seen the prayer. What has been rejected by the tribunal has again been prayed for after 2 years, 3 years.
Because, my lord, I tell your lordship,
So let him file another one after another 2, 3 years.
Let-
Continue
kindly
doing
cease the
this.
prayer, kindly cease the prayer.
We have seen, therefore we are observing. You may look and read again.
No,
Come to WPST 212. Come to page 49. What does 40 at page 50? What does it say? No CPF, no GPF. Now come to page 68. Relief sought for A. What is this?
that is why I am telling your lordship that, my lord, this gentleman proceeded.
He may have whatever he has in mind.
No, because
Is this permissible? That is what we are on.
But
Is it maintainable or permissible?
if in the Milord, I have twofold prayers. First, Milord,
He is more interested in litigation.
Milord,
It appears so from the
that-
record.
Milord,
Very much interested in litigation.
Milord, your lordships kindly have the charity to consider if doctor has been
Sir,
denied
we
his
are not on this. We are not on that, what you are trying to introduce. We are looking at his conduct.
that unless and until
Such a person, he suffers a judgment immediately for the same thing.
paragraph
Doctor,
I'm extremely 81 Milord, kindly Milord permit me my submission. A petitioner submits a petition that the honorable tribunal appreciating the of the petitioner.
which time the tribunal erred? Which time the tribunal erred?
Tribunal heard Milord 3 ways.
If this error was committed by the tribunal, which time?
Counting the service, this is
Which time we are asking you?
this time means Milord, this is the
You are saying the tribunal has erred, committed an error. Which time?
Milord, that is we are the responsible. That is why I'm saying
Which time the tribunal committed an error?
tribunal Milord did not ignore, did not take into account that I have twofold prayers. One Milord, I said erroneously that CPF to GPF conversion, that is not applicable to me. Your lordships are absolutely right. I made a wrong prayer. Number one. Number two, I said that my qualifying service, 34 years should be counted. Milord,
By which application you raised this?
Calcutta, private pension
For a qualifying error.
presentation is there.
Adding only to the docket.
No. I am Milord. Milord. I bow down. The court never encourages. Yes. 2018 to the pension.
That please one count this period of 34 years as my qualifying service. Just shows this prayer.
Page 28 of the supplementary affidavit.
This is my first OA
This is the first OA.
of 2020.
Yes.
No, সেটাই
That was not there. This is no, your lordship has asked me when did I make such prayer? I'm duty bound to show. Page 28. I shall be grateful if you kindly fix my pension on and from 1173. As per records, I beg to draw. How could you? This is over.
There is no claim for a qualifying service.
Kindly cease, I have made the due to observation. Will not interfere with the past service of the doctor concerned insofar as leave and pension benefits are concerned. A certified attested.
Service. Say 34, 35 years I have served.
Yes, I have served. Yes.
As qualifying service, whether that bears today or it is already over.
Milord, the order. Reading page 5 of this of your lordship supplementary affidavit. I'm sorry.
This is the third way.
No, this is the 771/2010.
Correct. So now this is the third.
First one.
So what we are saying
This is the first one. Your lordships. No, Milord, first I came. Milord, kindly says, Milord. No, Milord, I'm sorry, Milord, but because I kindly, Milord, read this, your lordship specific. No, because no, Milord, it will be ended. Milord, if you're Milord, I know it's a judicial mind, I can reopen it, Milord, kindly, Milord. No, Milord, your lordships, first of all, I am, Milord, with humility. It's a pro bono litigation for us, Milord, because of this gentleman is facing a humiliation. Your lordship, Milord, cannot. No, a person, Milord, 2010, Milord, time says, your lordship's court are flooded with many litigation which are pending for 26 years. It is a question. Now, it is a tribunal. Before your lordships, many a times, Milord, because of our incompetence, your lordship, when I applied your lordship's independent mind, your lordships always in a habit of looking into the law. After, Milord, consulting the records, the tribunal, unfortunately, Milord, it is we the lawyers, we did not, Milord, mutually cooperate each other, for which, Milord, justice has been denied. And I request you, Milord, that is, Milord, I have two submissions. Milord, no, it can depend on a fact. Milord, kindly says, first your lordship specific query, where is my qualifying service? Milord, I'm bound down to know that due to answer your lordship's query first. Mr. D. Paragraph 3, in the above context, as of senior accounts officer, office of the DG, addressed to the principal state library, and found that letter I find that according to DG, the question regarding counting of past service is required to be decided by the finance department in consultation with its official record. Mr. Sarkar adds that should also consider the judgment of the such and such. Mr. Such and such. This application, but directing the finance government to consider whether the petitioner is hostile. This was the first way. The government said, now I filed a content application. Kindly see page number 70.
This order contempt proceeding was dropped.
Yes, Milord, I'm extremely grateful.
What happened after?
Similarly, the government said, Milord, in this connection, the relevant order of the Honorable High Court, it appears that the Honorable High Court directed the state government to grant benefit of the government scale of pay and fixation in terms of the Health Department order 30th May 79, and there appears no order relating to pensionary benefits. On the other hand, as per the order, the absorption will not interfere with the past service of the doctors concerned insofar as leave and pensionary benefits. It has also been stated in providing promotion and gratuity past service during which GP fund has enjoyed will be taken into account. Provided that the employer's share of contribution together with interest thereon credited to government as gratuity is a part of pensionary benefit. Having regard to the judgment of the Honorable Court, the spirit of the GMW, it was decided that the risk management, which was covered under CPF benefit only, the period of service of taken into account for qualifying service for pensionary benefit. You are therefore requested. Miller, kindly seize the unfortunate part of the unfortunate part is this: there is a law, and everyone overlooked. Page 5, yes.
Page
Right. After that, Willard, for implementation, I filed a contempt.
79.
Wait, after that, CP, after way number 2, yes. I'm extremely grateful. Way number 1297, 2015.
Page 37.
Page 37. 2015. Page 97 of your lordship's brief. 37. I'm sorry, Millard. 37.
37, 1297.
Page.
Huh.
Got it.
1297. Page 79. Page 79 is 26 June, 25/5/2012.
Then this was subject matter of challenge 1297 of 2015. I have challenged the order in page 79. Page 47. 47 real portion.
The order at page 79 is under challenge. 25th of May, that is under challenge.
Under challenge. Yes. In this Millard, yes. 127.
97.
124.
Page 52, 53.
1 to 4. 1 to 9. Just check it. 1 to 9.
Promotion and gratuity.
1 to 9.
1 to 9.
1 to 7.
1 to 9.
The tragic event. So for the applicant has submitted the presentation dated 18/12/2015 where he wants to pay the CP along with the interest for the purpose of contempt service in the light of the Honorable Court judgment in 2024. However, the decision has been communicated to him that the counsel for the applicant has submitted that his purpose would be served. Judge, then
page 163.
Page 163.
আমি একটা contempt করলাম for non-compliance.
এটা at 164.
Although no, it was directed to be considered.
That challenge to page 79 is what?
79, my lord, I have challenged, but the court had, tribunal had said the consideration.
That is allowed.
I said if it is said because
The relief regarding the page 79.
Millard,
What is the representation that was considered?
now they consider present order 163,
164.
18 to 2018.
18 to.
Yes. Come.
1812, 2018, 134. এটা কি 134 বোধহয় Page 134, Lordship. 134.
So again, the same.
Has not. You will not allow me to read. No, finally, there are certain difficulties. As you know, the division was appointed 173 as ex-management. These facts are required to be gone to. That earlier, no. It was very as far as the tribunal, my lord. This is the order. That is the my lord kind sees. By what time? 16 share on the signal along even for the purpose of counter service, not from 74 from which was not counted as qualifying service for the purpose of calculation, and the person accepting one share of the 74 position. Absolutely able to share of the signal as and when I found the form. That's I've said that the as per the because I categorically stated. So it's not implemented. And if one
You may say whatever you want in the representation, but we have already gone through the tribunal's order. It was on your submission that the tribunal allowed. Tribunal did not say anything. We have read that order at page 129.
Page 29.
129.
129, yes.
You said that I want to go to them, let them consider. Tribunal said, all right.
The tribunal,
Tribunal said that they should consider.
tribunal when said, Willard, is it whether I'm correct in submitting, but tribunal should be written in the my representation. It cannot be said without at any point of time, tribunal was not aware of the fact what was
It
there.
has not taken into consideration anything. It says you are requested to pay back CPF, you go and read that issue.
Categorically state on 2018, tribunal's order which your lordship has seen, this may not be categorically said, but this is uncontroverted. The state has never.
All right. So now then there is
And
representation.
79, if these issues had been addressed, 79 automatically would have been addressed. This was not addressed, and 153, my learned esteemed senior friend has
Then
shown
reasoned order at page 163.
163.
Again, perhaps the same thing
No.
is going in
163
circles.
kindly says, what is the kind of reason? Is it reasonable this question to myself? It was for some. It means certain facts. The honorable tribunal such and such respondents to consider the representation of the petition dated 18/12/18, treating this order such and such, taking into the account of the honorable High Court judgment 2004, for decision and comment. Service. Service. Small government order posted such and such. Superintended from government service on 8 2007 and the principal accountant general. In the qualifying service of documents instead of service 617 gratuity
Similar some circumstances of other instances, such such and such are terminal. Therefore, after considering the intergovernmental situation, it is over. Such and such are instructed to proceed is contribute to the provident fund account into the general provident fund account as well as responsibility. So the finance government case is disposed of.
Then Millard, kindly see what happened.
Then I find
What is the period they are counting from 95 to 2007 only?
19 years.
From 12th of August 1988.
19
As
years.
per the order of the High Court, which my learned friend was the petitioner, that order, it was 12th August 20.
So that is during his service in the
During his service,
Cancer Institute.
during his service in the
Because
country.
he left that in 95.
95 he came into the higher duty, but
So 95 till 2007 he was in state government, 12 years.
state government, and prior to
Prior thereto from 88.
to the order of the High Court, 12th of August 1988 is where is being counted, Lordship. And
He wants from 73 to 88 also
as a part-time visiting surgeon, Lordship,
on honorarium.
on honorary.
That we have seen.
Millard, kindly see the law. এই একটা বই আছে এর অলরেডি বলছি ডিসিআরবি রুলসটা আছে
Yes, DCRB rules we have.
Oh, before that, Millard, no, no, ওটা দেখাচ্ছি, let me see, no, no, this has not been placed.
DCRB.
Millard, first, Millard,
Death come retirement.
my supplementary affidavit page 21. This what?
Absorptionটা কিভাবে টার্মস এন্ড কন্ডিশন
Showing. This will be some conditions based on ship's attention. 79. Some conditions are observation of government signals of ex-members of should show the some subjects from just now and look at the such and such a we calculate college. The terms of to have the same sales load. The nature of the institution was such that such part-time assignments were determined to the interest of the institution. In order to secure the services on a whole-time basis, the institution to which they attached, they were in this case, not from continuing or accepting part-time assignments elsewhere. Similar demand on services of the senior Shivashodan and existing in this regard, making a similar transition will be considered. Absorption of this service will not interfere with the past service of doctors concerned insofar as pension benefits are concerned. So far as benefits are concerned, but for the purposes of determination of seniority, etc., the absorption will be criterion. Absorption. In the status, the status enjoyed under this management consideration, such status was not forced to attain. Service very much benefits into account the share of contribution to it interest the administrative to government. If that is to occur in the expansion sector, is almost contribution into a vacancy in Westminster health service within the solution sector of the institution or into a vacancy non-existence if it is not covered by the solution sector. Such a vacancy is already filling. But not instead of those vacancies, not according to part of the service conditions and source of personal benefit as regards those stickers was accepted what we call with reference to the municipal limits that we have to introduce in the interest of the institution from time to time. Government decision has been listened in the exigencies of public service are concerned. So service government it is not absorption of the service of the concern in so far as potential benefit are concerned. So 21, 22 and 20. And here why what I have said, my we Millard continuously tribunal did not take into an account. On the contrary, state said, I said also Millard that my contributing provident fund I will refund, whereas Millard admittedly there is no contributing provident fund. Question is how the court will view Millard such factual error, Millard.
Question is after it is settled, can you retake again and again for the same thing? That is the question.
Millard settled means I Millard
Whether it decided rightly or wrongly. That is not the issue.
it is Millard
Decided again again tomorrow you will approach. Never can you keep doing this?
No, I cannot.
To come.
No, I cannot. I have shown your lordship that your lordship said, Millard, your lordships maintained a consistent stand whether you have made any prayer for your qualifying service. I have shown what is the order. I have shown second, Millard, what is the ramification in law. Millard, my prayer
Is it open to consideration once it is decided in a proceeding?
that is Millard, I am grateful. If I can show from the Supreme Court, if I have correctly understood their lordship's mind, many a times I don't. Millard kindly says, Millard, kindly Millard have the charity. What is the ramification? How did Millard Supreme Court, the 5-judge bench, Millard had considered? It is a writ of certiorari. If your lordships many a time, Millard, I expect and trust that your lordship on this time also say that what is the law in this regard. If the law clearly, squarely applies to me, if the fact is uncontroverted fact that I have pass count service 34 years, if it is a fact that 1954, 1 SCC, page 905,
1954.
1 SCC, this was a judgment.
We are not over with the facts yet. So after this reasoned order, what did you do?
Which
After the reasoned order at page 163, what did you do?
after this
Reasoned order.
reasoned order, way 706.
706. So this is way number 3.
When last third way,
Third
and there is fourth way,
706 of
2022,
2000.
2022.
So one of these the orders passed in OA 706 is subject matter of one of these writ petitions.
Yes, yes, right. Next matter, item number 4.
And then that was, where is the order passed in 706?
Page 49,
706.
49, order dated 16th May, writ petition, page 49.
Then where is the opportunity for filing the next OA? Now tell us.
Yes, I have said, my lord, your lordship is absolutely right. In paragraph 15, I have said, kindly see. I have said, now I am also, my lord, that page 15, paragraph 15, page of your lordship's petition, page 10.
Which writ petition? The
Yes,
second.
the petition number WPSC 212.
Oh, yes, paragraph 15.
I have so, my lord, that is the awareness to the matter. In Calcutta states, the is no application. 706 to the application. It's put the advanced stage of the petitioner, he means such way as on the records, the application rates in the file. Stores the taken for consumption and selling on the respects to the application, review of the order, considering the order, still the application or CO 622. I have said so. Now, what is the ramification? I said there is a mistake. In 2 cases, I said, now current says what the Supreme Court has viewed this mistake and not in this
So
case.
therefore, we need not go into the second WPSC. We'll confine to the first. First is.
I leave it to your lordship's wisdom. I leave it. I
know what is to be done. You are there to assist us. Therefore, we are asking you.
No, I said, Millard, if I survive on the first one, then Millard, the second one, absolutely mistake.
So therefore, that is why we are saying we'll confine to the first.
But second one is the 728 of
6328.
Can it survive if the earlier order is set aside?
Item number 4, Millard, the kind of
Can it survive if the earlier order is set aside?
Yes.
Cannot.
If I succeed in the first one,
Therefore, we are saying. So which one is the first? In which one first? 212 is the first one or 213 is the
13.
this the matter number has the earlier order. Yes.
Millard, admittedly, Millard, CPF state said CPF, if I submit, the CPF does not apply to me. The court tribunal
Therefore, if we have what we have understood, if it is correct as per your submission, then prior to 88, you say I have served the institute, that service is to be counted. You are relying on rule 21, 21A and 22.
22, rule 22, only 22.
Only 22.
Only 22, rule 22 of DCRB.
Rule 22 only. So rule 22, if you rely upon,
and as well as the memo dated 30th May.
That we have seen, yes, that we have seen. 79.
79.
That memo of 79.
Memo 79.
Yes.
That is not in conflict with, rather, that is in essence the compliance, securing compliance.
But that memo which you are relying upon, that states that it is available for those who were in employment and for whom the GPF was being deposited. Admittedly, for you, there is no GPF deposited.
It is for gratuity, not for leave and pension.
No, it is for everything. Please read again.
let
Please
me
read clause 5.
Clause
Please
5
read
is
clause 5.
pension and
Kindly. I may be, my understanding.
Please read clause
Yes,
5.
yes. Oh, yes, you're welcome. Supplementary agreement.
79 memo, clause 5 at the next page, second page.
Page 21. Clause 2, absorption in the West Bengal service will not interfere with the past service of the doctors concerned insofar as leave and pension benefits are concerned, clear, but for the purpose of determination of seniority. The date of absorption will be the criterion. Next, 5. In and gratuity, service during which GP fund benefits were enjoyed will be taken into an account, provided that the employer's share contribution together with interest thereon is credited to government.
So where does it say despite this, a pension will be given?
Yes, clause 2, absorption in the West Bengal service will not interfere with the past service of doctors concerned insofar as leave and pension.
Past service,
Yes, I am
not
talking past service.
visiting lecturer on honorarium.
Willard, no. Before that, Willard, in the case of
It means that for person
Because-
who was appointed, who was depositing GPF.
Willard, kindly see example. So, anything and fine. This is what is the interpretation for a constitutional. It's our staff of the management guidelines. It shall be clear how the hospital was seen that by the terms of their appointment on the management, they were free to have.
Where is your appointment order? See, you have been a visiting lecturer or visiting whatever you call it faculty.
That is there.
You are not an employee.
Millard, kindly cease today, Millard. This is too late in the day, Millard. To
Claim to the contrary. That's what we are saying.
Court can ask any question under section 165 of the Evidence Act. I am bound to answer. Kindly cease what is the language once again? Cease.
79 memo.
Yes,
Yeah.
Six. In the case of the terms of the appointment under this management. Take note, they were free to have terms. Yes, sir, but the nature of the institution was such that such practical assignments were detrimental to the interest of the institution. Secure the services on whole basis, institution to which the to make a similar so the doctor consider service of the doctors concerned. Doctors means those doctors under management. So far as benefits are concerned, that for the purpose of determination, second absorption, now service and the confirmation declaration of consequence permanent status in the same or under shall service. Neither the tribunal state council
Not getting any pension.
I am getting pension counting 19 years.
19 years of qualifying.
19 years. I cannot say that I am not getting. Now, Millard, kindly stand. Page, Millard, your lordship's answer question, Millard. Annexure B, supplementary page 23.
Yes, serial 5, we have just seen.
Far ahead of our time. Far ahead. Millard, I find pleasure, Millard. Kindly see, yes, that's just a minute. Millard, kindly see the next page.
Yes.
Page 24.
Yes.
This is an issue Cancer Institute. Goes to Subhash Chandra Joint Institute, 1571, some the institute and different capacities shown as below. First July surgeon, these they are 1.71 to 31st December 71, a seat of surgeon, 72 June 72, June surgeon. 172 surgeon 4585 to 8 August 1995. Register I was. Now, Millard, the lawyers and the tribunal both both, my lord, with confidence, my lord, committed a mistake. We did not bother to show the law because your lordships are not everywhere asking the lawyers to file law, to show law, to show law. Sometimes, my lord, we, my lord, take the chance. Representation, consider, and then, my lord. We never invited tribunal to decide the rights of the parties. And by this time, 20 years will have gone. 2024, your lordship asks the erstwhile government pleader, government advocate, when the new judge will come. He was confident that the file is in the governor's house.
In December, it will be done.
In December. Kindly show the confidence and knowledge. All are innocent of facts and law. And ultimate, all the lawyers, they have come here and litigants are suffering like anything. And, my lord, the government is finding, this is known as in English, my lord, epicaricacy, finding a malicious pleasure, my lord, by seeing, my lord, the miseries of others. This is an act of epicaricacy. What can be done, my lord? And your lordships, whatever your lordships feel, I will not waste your lordship's valuable time. Your lordship encourages the bar. My lord, these are last resort. Cannot fathom, my lord, the plight of and the misery of the common man. Cannot fathom. Lawyers' incompetence, judges, my lord, never invited. Sometimes the lawyers, the bar, that you press the law, confront the lawyers so that the juniors can get prepared. Because that is why I said, initially I thought, why your lordships put so many questions? Ultimately found, my lord, that if the parties go to the higher forum, at least we can show that by reason of this altercation, we placed all laws and documents. Many documents. I committed a mistake. I cannot, my lord, play with your lordship's court. But the question is, what is the ramification in law? Supreme Court says that inadvertence, mistake, negligence, if it is in ignorance of law, the certiorari can be issued. 54 Supreme Court, 2015, volume 13, SCC, page 132, paragraph 67.
So in the in 706, which order you have challenged?
Barco.
706. Wait, 16.5, right?
16.5 to Barco.
5 to 2023.
Your lordship 5 times asked me that if the first I survive the second, I took, my lord, half an hour time to understand. At least 5 times called me. If I thought, no, I will appear in both. That is, I must be frank to your lordship. I took at least 15 minutes, half an hour time to understand a simple question flows from the bench.
Because most of the times you presume that a
Yes. In my home and here also. Page 30.
page.
The recent order, my lord, does not.
No, which was the order challenged in 706? We are asking.
Just my lord, since it decides nothing, I have come here. 706 says in view of the earlier order, page 30 is my.
Therefore, 4321 was not put to challenge.
I said that tribunal should have been considered the.
Please give us the facts. 4321 was not challenged.
Not challenged. Because 21,
It was not challenged.
21 does not decide any issue, my lord, placed before the court.
Therefore, you consciously did not challenge it.
No, I said, my lord, I said only that what mandatory direction to issue competent respondent authorities to forthwith act in strict compliance of the Honorable Tribunal's order dated 2011-29 as delivered in way 1257 as well as
1297.
1297.
Yes.
1297 2015 as well as the order dated.
But that order was already complied by issuance of this recent order of 43.
No, thereby disbursed the full monthly pension. Full monthly pension. 19 years they are giving. I said 15 years. And CPF doesn't apply. My lawyer said, my lord, that it applies. I induce my lawyer as if I will pay the amount. Ultimately, because, my lord, at this age, my lord, I said, my lord, paragraph 14.
No, but then this remained unchallenged. Plus, the other thing is you have never deposited GPF. These are two things.
Deposited, my lord, that the GPF, CPF not applied to me. Had it, my lord,
that 79 memorandum says of those persons whose GPF was being deposited.
In case of, my lord, kindnesses, I'm extremely grateful, my lord. What does it say? There is a 22. Duty. Service motion.
It's well enjoyed, taken into account. Then shape of contribution together with interest.
There is a question of depositing CPF amount.
So that did not apply to me. Rule 25, we are saying to you. Rule 22, rule 22 says, rule 22, rule 2 provides so.
If there is no.
Rule 22 provides so, there is no conflict. But I finally said,
Yes.
and if your lordship say that it is your mistake, I said yes. If your lordship say that you should be cautious, I would say yes. No confrontation, my lord. But my lord, all said and done, my lord, whether I'm correct in submitting that whether the tribunal was under binding duty, my lord, to keep the law and to decide disputes in accordance with law. And when in this case this has been done, in this case this said two things. Certiorari is not a jurisdiction. It is true. The decision was made. Decision, the decision making process was based on is a action of law and evidence of law. It's the submission of lordship that and this 79 was not considered middle, which is not in conflict. And there is no element of misrepresentation. And first and last middle, the reason of this middle is not question of prejudice, that is the state. And at the end of the day, the state cannot say a single time for any school will come back, long-standing passionate school will come back, Lordship's House Constitutional Court. The reason of the conduct, the state had suffered prejudice because I have willfully benefited the reason of such mistake. If the actual matrix work, the Supreme Court has come in the judgment 2015. SCC, page 132, although this is in respect of an amendment, but the order under Article 141, আমার জাজমেন্ট বার করতো একটু জজকে দিন না এটা इसको दी এটা এসছে
কি দিলে আগেরটা এটা কত
এটা 1513 এসসিসি
এসসিসি কত ভলিউম
13 এসসিসি
না না ইয়ার
13 April 15
2015
13 এসসিসি পেজ 132
SCC 132 এই তো ভলিউম 13
just a minute
আমাদের 1954 পেজটা বলবি
here my lord just a minute
ঠিক আছে
it is settled by August 20 I mean we have to retain that privilege to is this but it is settled by to the administration of justice. Refuse to just remove some state or fractional procedure are also satisfied that the applicant was figure or by his he caused injury. I'm sorry. Paragraph 20.
Unable to keep up with.
I'm sorry. No, I'm sorry. I was a little bit nervous.
20.
Sorry. Paragraph 20.
Yes.
দেখালাম procedure to increase upon your lordship or by matter of cost. Is a exercise jurisdiction if I can take this. So that are the circumstances which will be consideration. Elements, even if we have the states, they will be sort of a trial code. So is there is no provision of this code because this is not that code. Wants to see it's 90 which composed of Justice MC Mahajan, Justice Vika Mukherjee, Dillian Bose, Inji Bhagavati, and Ayat. 5 judges bench. देखिए बार को 11 and 12. 11 it works. In such cases, such an operation of sin also such of law. And so, such rules are such a has justice. However, it seems to us up to large and good source to sexual incidents. It's still but committed uncommitted is not this self-committed by reason of my such act of negligence. If that is not there, permission is a continuous cause of action. And when I'm not sitting on the fence, Miller, whether Miller under this, because Miller, the court is here to unravel the truth. The truth is, Miller, I have spent my 34 years of life. The truth is that I am entitled to pension, pension up to 19 years. The truth is that when I was a visiting surgeon, the truth is that I am 22. The truth is that 1979, attracts me. Such attraction is importance because of justice. Ships have taught us from the Supreme Court, Miller. There is a passage. Justice will be control stretch its hands. Of 35 years, then I can resort to the position of law that in this case I have not committed any fraud. I have not caused an injury. If
done any error or lost, that is I caused to myself as a doctor. There was no occasion for me to say, Milord, that I am that CPF I will return, when CPF admittedly not applicable. There was no occasion for me to impress that did not point out, and even the state also did not point out. Justice Dipankar Datta, Milord, when his lordship was in the bar, Milord, he had made a specific submission that he was a junior standing counsel, that it is our duty as a state counsel to apprise the court about the correct law.
So there is no order after this 4321 order, reasoned order, there is no order. In pursuant to that, there is no order of the state government. Because that reasoned order gives a direction, but no order was passed. Yes. Ah.
Principal only said I was not under CPF, that is all. No,
No. Please see page 164 once again, second paragraph at page 164.
No, answer is no. Subject to what my learned senior friend is.
That is what it.
Answer is no.
164. Applicant was released.
What happened pursuant to this? This was a direction by your director
Yes.
that certain steps were required to be taken. What did they do?
This is what I've asked for, Lordship, to know what they have done. Therefore, Your Lordship, keep it next week. I'll get the instructions. If anything has happened, because this is in 21. After that, what has happened? Whether nothing has happened.
Mr. Basu Leonard.
স্যারের বইটা
Matter of five. My lord, in this matter, my lord, I am praying for not today and not tomorrow.
Why, sir?
But the senior my Supratim thought he was here. He was feeling sick. My leave report, man.
Not today.
tomorrow change.
Item 6 and 7.
My lord, Mr. Shoma Majumdar, learned senior counsel appearing
Lord,
the applicants.
for the bank, your lordship, if my lord recalls,
My lord, kindly grant us.
my lord recalls, your
today.
lordship, it is that matter where Honorable Supreme Court has remanded back the appeal because, my lord, the Yoko Bank, your lordship,
Did not point out the provision.
yes, your lordship, we have thereafter here, your lordship, we have submitted the rules, my lord. As per my lord's order dated 2nd of July, your lordship, we have served the writ petition, the original writ petitioners, my lord, but the status of the report is showing, my lord, out for delivery. So, my lord, kindly keep it, my lord, the day after tomorrow. Oh, my learned senior is appearing then.
Now you are sending notice to him only.
My lord, we have
He is
sent
the complainant.
we have sent them on their
He is the complainant. Now you are represented.
we have sent them on their personal addresses.
No, but he is the person. So
I'm not
there is no issue of service now. They are seeking a judgment. Let us. Mr. Majumdar is not. As prayed by learned.
Grateful. my lord. Ah.
Party. Number 8. 11.
Lordship, I am for the appeal in Lordship. I'm praying for not this week in this matter, Lordship.
आज का डेट क्या 20. Yes.
Lordship, I'm praying for not this week in this matter.
Why, madam? Let's see.
But the suit was declared on cruelty ground. I'm for the respondent wife. I was the petitioner in the Willard suit.
You are the appellant.
Lordship.
As prayed by the appellant list after. It has come by way of assignment.
Yes, madam. Assigned.
Your lordship, similar pair, we seek a lot this week. This matter has come up suddenly after assignment from the Honorable Chief Justice's bench.
Which item?
Item number 9.
Before it's called.
$27.
Number 9.
Yes, sir.
1 week as prayed. As prayed, list after. As prayed by the appellant advocate for the appellant, list.
Number 10. 10.
Sir, my lord.
Yes.
हम कॉल करें ऐसे सबके ठीक है सर ठीक है सर चलो कॉल करें
What is DODL?
ये पिटिशनर इन पर्सन प्रोफेसर डॉक्टर A.K. माइती और no Kumar माइती. I also-
This matter, my lord, I am appealing for the UGC, my lord. Copy I have not received. I am for the.
No, copy, my lord.
You are appearing for DODL.
My lord,
What is DODL?
University Grant Commission.
My lord, I have already sent by a speed post and also submitted to my honorable court also affidavit in service. That is addressed to the secretary to the University Grant Commission, New Delhi, head office. I already
Give
submitted
me a
that.
copy, I get it, Xerox, I return to you.
No, Xerox, but I also, my lord, I also.
I will get it, Xerox.
No,
I return to you.
my lord, I also addressed to the secretary
to the University Grant Commission. That is that is
You are right. Everything is correct. Kindly give me a
Eh,
copy. I will return you.
that is 2.
Give it tomorrow or day after tomorrow.
Tomorrow it is because
Which respondents are represented? First, we want to know.
I am appearing for the respondent university. He
University,
is appearing for the
UGC.
university grant.
So Union of India is also represented.
There is no.
Union of India must also be a party.
State is also not responding.
Huh?
State
I-
is made
no,
party or not.
No, I don't know. That is there. I have already sent by a speed post 15 respondents, my lord, including state government.
And we have understood, you have issued the notice, you have sent it to all of them. But if they are appearing and they want a copy, why you are averse to allowing them to get a Xerox? They will get a Xerox.
Now, this is my copy. I just submitted.
So they will get a Xerox. That will facilitate your consideration.
Acha, acha.
There is a return to you.
You just, this is my copy.
You have a copy.
স্যার আমি আপনাকে দিয়ে দেবো ছেড়ে দিন ও স্যার ওনাকে দিয়ে দিন আমি আপনাকে দিয়ে দেবো I will get it from him. I will supply. Day after tomorrow কালি
Day after tomorrow, I am out of station. After a
You
week,
tell us when you want. After a week.
after a week,
Which date is suitable to you?
any date,
We'll keep it on 29th.
29,
27th,
29, 29, that is okay.
29.
Difficulty on 29th.
29, that is okay.
Usually a date suggested by the court.
I
is-
have no
Yes,
difficulty. I am here.
As per your lordship.
the has prayed. DL, you've used an abbreviation. What is DODL?
Reason that is without my lord.
Department of the university. This is the department of the university.
For Directorate of Distance and Open Learning.
This is a department like Bengali.
Got it. Yes.
I'm grateful.
29th.
29. স্যার আপনি আপনাকে হোয়াটসঅ্যাপ করে প্রশ্ন হ্যাঁ ঠিক আছে 11.
Yeah, item number 11, I am for the appellate, my lord. Your lordship's last suggestion was that to file a paper, but this is the informal paper I have prepared. My predicament is this, my lord, my client, my counsel is out of Calcutta, my lord, today, but I am praying, my lord, make it not to done tomorrow.
You have served copies.
Yes, sir, I will keep copy. Yes, sir.
Well, I am just filing this paper, will maybe accepted.
The informal paper books are taken on record.
Yes. Also 12.
Yes.
Well,
You are
item
appearing.
12, yes. Well, item 12, which is the review application, mine. Review, a review application. But, my lord, I had a talk with Mr. Saram. Both of us in difficulty issues. Let it be fixed up, my lord, on Friday, Thursday, I should say.
Friday.
Thursday.
This Thursday.
Okay.
This Thursday. As
Thursday, 2
prayed by
p.m.,
the
my lord.
court. Thursday, we have any matter, 2 p.m.
Thursday, 2 p.m. ठीक है जी?
Friday. Friday, 24. 24. 23rd also. Monday. If you want 2 p.m., then we'll have to shift it till Tuesday.
On Tuesday.
Tuesday.
Tuesday next
28th. Yes.
Tuesday week.
Because every day, Friday, we have 2 p.m., we have matters fixed.
Would it be fixed up on Friday even then?
No, Friday also I checked up. We don't have, otherwise there would be no problem.
All right, man.
27th Tuesday, Mongolbar.
You have a copy and everything. Already.
28th August.
28th. As jointly prayed. As jointly prayed, list on 23rd. 28th. At 2 p.m.
28 2 p.m.
Item 13.
I'm on behalf of the applicant, my lord. I pray for not today because my learned advocate on record did not come to court due to her illness, my lord.
Not today.
Great.
Item 14.
My lord, item 14, I beg to appear virtually, my lord.
Yes, please.
My lord, I couldn't appear physically. Now, my lord, on the last occasion, your lordship pleasure was to give us a direction to file an supplementary affidavit. Now, my lord, we have filed the supplementary affidavit.
Regarding service.
Yes, my lord, what happened is, my lord, the order was to be, my lord, supplied to them by 28th, and the date is very vital. If your lordship kindly takes up your lordship's direction appearing at page 23.
At page
23 of our application, my lord. Before your lordship takes up the supplementary affidavit, kindly takes up, my lord, the order that we have said that they have violated. That is at page 23. My lord's pleasure was, my lord, to give us a direction to file an appeal before the authority, but that has to be availed within 3 days. That your lordship will find, my lord, in paragraph number 4 and 5.
Page 24. Where?
by 28/11. Yes.
Yes. Now, my lord, if your lordship kindly, my lord, takes the pain of coming to page number 41, where we have annexed the dispatch, my lord, receipt, that on such and such date we have dispatched the, my lord, your lordship's direction as well as the appeal.
Just one day
And-
before the last day.
No, my lord, it was received on 28th. That is why, my lord, we sought the leave to file the supplementary affidavit, because in the petition we couldn't annex that. If your lordship takes a page 41, and the corresponding proof of delivery is the supplementary affidavit. Your lordship will find in the supplementary affidavit, it was received by them on 28/11.
No, what is SO? This is not to the addressee. It does not
The
say
last,
delivered to addressee.
my lord, then I will have to confirm. If it is not within 28, I cannot, my lord, raise the counter application.
Or we are saying you have filed it. You must have seen. It does not say delivered to addressee.
I was under the impression that it was received by this office. SO means I thought it was in the office.
No, no, no,
My
no.
lord, it would have been my mistake.
SO means sub post office.
My lord, this is my mistake. That is my mistake, my lord. I need not proceed any further, my lord. I will have to take instructions. If it is not within 28, my lord, I probably cannot improve my case. I will not. I extremely, my lord. I'm sorry, my lord. I tender my apologies, my lord. I was under the impression, I was told that is.
What is then you have no case because this does not show any.
Absolutely, my lord. I would not, my lord. I have to take instructions because I was told and I was informed that SO means the office has received.
See, this is not subject to an instruction.
My lord, I take the, my lord, I tender my apologies. I ought to have checked it out, my lord. It is my mistake, my lord.
So there is no occasion for us to entertain this.
Yes, my lord. If it is not within 28, then it is.
Advocate.
I extremely sorry, my lord.
Yes, no problem. Mr. Sanyal, who has.
Madam 15.
I am for the appellant. On the last occasion, the court has put a specific query on the appellant that whether our prayer will confine to the revision of our remuneration or not, my lord.
Whether?
It's for the deed writers.
In respect of the deed writers. sorry, the copywriter.
Copywriter.
Inadvertently in the order dated, it has been mentioned as the deed writer, but we are the copywriters, my lord. And my lord, we need some more time because the fate of the case will affect throughout the West Bengal of the deed writers, my lord. And that is why I have been instructed that they will call for a meeting, and some of them are from North Bengal, my lord. That is why we need some more time. And one more thing, my lord, the similar matter being FMA number 86 of 2021 is appearing in the list of Justice Ravi Kishan Kapoor. And my lord, so I have to mention before his lordship that so that since my lord has substantially heard this matter, that should be tagged with this matter.
So instead of deed writers, it should be copywriters. At the very outset, when the matter
Twenty-nine.
Then 16.
Your Lordship, for the petitioner, kindly bring for the matter not to be taken this week.
কেউ আছে এখন দেখে নাও আছে কিনা দেখে নাও না 17 না 16-তে এসো রবি এসো 16
Lordship, praying for the matter not to be taken this week.
you address us, what is wrong with this order? Why you have not availed the statutory remedy? Since 2019 to 26 and you still want an adjournment? What is this? Just want to keep this pending? The court said you avail remedy under 156(3) CRPC. Why you are not doing it? Yes, tell us.
Lordship, I am understanding, but my landlord legal counsel is suffering from sinus and he's under medical treatment. He cannot breathe properly, actually.
There is nothing in this matter. You address us. You are the advocate on record.
No, no.
Then why you are here, sir? Why you are here?
If I ask you for a time, Your Lordship.
Your senior has a sinus problem. We appreciate. Where is the advocate on record?
He's not in the court, actually. He's under the.
So nobody is concerned. Then it should just remain pending. Tell someone to take a time. That's all. Ask them to be here, not today. No adjournment. Most unnecessary litigation you want to keep pending.
কালকে হবে not today.
Para 17. Well, I am for the appellant.
17.
Writ is still pending.
Read petition is still pending, my lord. So far, my knowledge is concerned.
Then pursue the matter there. What remains? There's
No,
nothing.
my lord, after filing of the appeal, my lord, several proceedings, my lord, were initiated by the, my lord, writ petitioner. Now, my lord, one contempt application.
We are not concerned with those.
No, my lord,
What is
another,
the
my
point
lord,
in pursuing
there was a settlement, my lord.
What is the point in this proceeding today?
My lord,
Tell us.
in these proceedings, my lord, I have taken, my lord, the ground in the appeal.
Argue?
That, my lord, without the opportunity of any hearing to me, my lord, order was passed, my lord.
Without opportunity?
Yes, my lord.
Who are you? The writ petitioner?
No, my lord. I am for the respondent number 14 in the writ petition.
Who is respondent number 14?
My lord, respondent number 14 is an association of boatmen, my lord.
Yes.
Well, we are for the appellant.
Your right has been preserved by this order. That has been deposited in the account.
Yes, my lord. But, my lord, so far, my lord, my instruction is concerned, my lord. There was, my lord, altogether, my lord, 15 lakhs agreed amount. We are entitled to
That is not the subject matter of the present proceeding. Don't try to introduce something which is not here.
Yes, my lord.
Only thing is the court said prima facie I am of this view.
Yes.
You may continue with the ferry ghat operation, but you deposit the boatman's due in an account. That is for you.
Well, we are continuing, my lord.
So
After
this
settlement, we are continuing.
Yes, hurt standard advocate Madam 18.
Yes. My lord, perhaps, my lord, this matter, my lord, your lordship is not having the determination to hear this matter, my lord.
Yes, why?
My lord, perhaps, my lord, this is a Group 9 matter, my lord. This is this is a fresh matter from arising out of a Group 9 matter. This is a fresh matter. This is not a hearing matter, my lord. Motion, yes. The lordship is having intra-court appeals of hearing.
Irrespective of
Only hearings, my lord. But this is a fresh matter, my lord. Your lordship is having new motion for a different group.
where is this supposed to be listed today?
The Justice Shorkar. Justice Shorkar, Division Bench of Justice Shorkar.
Let's see. Give the determination. The fresh matters are being listed there.
Yes, my lord. This was never moved, my lord. This matter.
May I just assist your lordship, being my lord's officer, my lordship knows, my lord, in our appellate side rules and original side rules, the determinations are both for division bench and single bench are given to the extent, my lord, that admission or motion and hearing. But in respect of a particular group, and some benches, both in single and division, they are given, my lord, the right to hear the either writ matters or the appeal matter, which are ready for hearing. Just like your lordships are having determination of group 6, lordship will find that appeal from orders under group 6 along with the hearing.
Irrespective of stage.
Under group 6. But
Under
for
group 6, yes.
6.
Yes.
But for irrespective of cases, it is only hearing.
No, we wanted to know where the admission.
Exactly. The usual, my lord, the fresh matter is to be heard before, my lord, Justice Shorkar's division bench. Just like, my lord is having the fresh matter for group 6, my lord, Justice Mantha is having for the fresh matter for group 7. So similarly, my lord, different benches, both in division and, my lord, single, there would be a jurisdictional error, my lord. And this is a fresh new matter.
Matters relating to group 9.
Right. This is a group 9.
We are informed by.
It is only, my lord,
number 56. 56. 52 na?
For orders se একটা।
Huh?
For orders se judgment pronounce করে একটা।
What? I'm sorry. I'm sorry.
5607.
Yeah.
Undeclared.
Send it to the chair.
Two PM at number 52. Lord, I appear for the respondent petitioner before the tribunal. My lord may recollect, Lord, this is that matter. What, my lord, the ICC recommendation was set aside by the Learned Tribunal as well as the disciplinary proceeding initiated on the recommendation of the ICC. So, my lord, I took a point that the tribunal also held that the complaint was time-barred and there was no extension of time given by the tribunal.
There was no
extension of time because as per section 9 the complaint has to be made within 3 months and it could be extended for another 3 months by giving an order by the ICC. There was no prayer. It was lodged after the period of limitation. On that ground, and the other grounds, the tribunal has set aside the ICC. ICC recommended.
The complainant has not challenged the order.
Complainant has never come. Has never come. The state is carrying on the proceeding. That's my first point. Second point is that it's time barred. And if the genesis goes, the DP was initiated on the basis of the recommendation only. The statement of articles of the imputation of misconduct, everything talks about articles of charge, imputation of misconduct, everything refers to the ICC report. So if the report goes, DP cannot continue.
So before the tribunal, the ICC as well as DP both were subject.
Before the tribunal, ICC proceeding was subjected. During the continuation of the proceeding, they initiated DP in terms of the ICC, which was not under challenge. We filed an MA.
The tribunal.
Bring on record that because that's not a subsequent event when the proceeding was going on. Tribunal first set aside the order of the ICC, and as a consequence, the DP was also set aside. Now, the government leader on the last occasion said he would argue the matter. Now, I am here today. My lord has fixed the matter, today. So,
My lord, I am praying for not to death.
I
Engage in another courtroom.
Ask him to come.
A short pass over, my lord.
Ask him to come. Ask him to come by 3.
5 lord?
3 o'clock. Call it 3.
हाँ GPA में होगा तो हाँ number 19
No.
Parent 20.
My lord, I am praying for not for today.
Same order. Same order.
Parent 21. Parent 22 and 23.
My lord,
This is a copy of Jaggo Bhattai's.
my lord, I am appealing for the appellants, my lord. I am led by Mr. Bihani, my lord. He is engaged in court number 37, your lordship. I am praying for a very short pass over, your lordship.
Well, that judgment, your lordship, explain.
MS so and so.
Okay. 27th. Parent 24. Correct.
There is none to represent the appellant. Stop.
I'm praying for an accommodation. My advocate will record his sick.
Very well, not today.
Parent 26.
26, my lord, I'm for the respondent. It is the state, the bank's appeal, my lord. The honorable single judge held in our favor.
What is a DP?
No, my lord, it was an writ petition challenging the disciplinary proceeding. The charge.
DP you say no.
Yes, yes, I'm sorry. The only thing is that, my lord, day after day, my lord, they have been
trying to delay the matter. Contempt is pending. Contempt has been, my lord, adjourned, signed by in view of the appeal. Now, my lord, the respondent, he is, my lord, more than 70 years of age. He has not been receiving anything, my lord, since
Appellant
2013.
is not present. We'll stop list in the next week.
Grateful, my lord.
27.
To the appeal of this state lordship. But there is a delay, lordship. What I could papers that I have retrieved, lordship, which an application for condonation of delay. There is a delay of 216 days, lordship. Now, lordship, lordship, in this matter, the records will have to be sent down because all that I could retrieve from the department was a copy of the application for condonation of delay. Rest of the papers they don't have, lordship. They've given me.
Why you are not getting it from Sarthak?
Not available because the appeals filed by the state are not with the Sarthak.
Huh?
Appeals filed by the state are not in the Sarthak. That is the problem.
Are not available on Sarthak?
No.
Why?
Lordship, the matters which are served on the state, those are uploaded. But the state appeals, lordship, this is happening with all the.
So a copy must be lying with your officer.
Lordship, office.
Whoever is the officer concerned, they must be
Officer
having a copy.
concerned, I've got instructions what the matter is about and a copy of the application for condonation of delay. Rest I don't have.
This is a service matter.
It's service matter regarding pay scales, lordship. The writ petitioner had joined in the post of a pass category. Now he wants the honors pay scale. Lordship, that is the issue.
Serve a copy first. Let's see whether service you have completed.
That also has to be, I don't have any, I mean, it's a matter of 2019, lordship. The order is impugned order.
Get a copy from your officers. They have filed it. They must be having a copy. Whoever has been in, who have given the instruction, who has verified, he must be having a
I have a copy of the judgment, and this is what I retrieved from my officers only.
No, the concerned officer who has
The memo of appeal and the stay application are not with them. That is the problem. But I have a copy of the impugned order. I have a copy of whatever instructions they want to give, but not the actual papers. That is the problem. This is happening with all the state appeals, lordship, because unlike an affidavit in opposition which is kept with them, I mean, very few of the officers have been able to supply us with the documents.
The DIS Howrah should be having a copy. He has shown the affidavit.
That should be sworn the affidavit. He is, I obtained it from him only. And that is all that has come. I'll try again, lordship.
How can it be? See, if they are asked for instruction, they must be having a copy in their office.
What they gave me was a copy of the application under Section 5, where the application for condonation of delay. That's all that I've got. This is the problem.
Last day we have adjourned it for you.
I know, Lordship, I know this is what is happening. I have to be, all that I can do is share the problems that we are facing, Lordship. It's been adjourned on repeated occasions. It's a 2019 appeal. So that is the only remedy left to me is to get copies. I'll be trying, but Lordship, otherwise, Lordships have been pleased to send down quite a few matters.
No, but we don't want to start this as a practice because you are not keeping your records properly. Therefore, a matter should be adjourned twice and thrice.
I understand, Lordship.
This can't go on. We have been telling you repeatedly.
Lordship, we are also helpless, Lordship.
You are not helpless. You have the might of state. You have everything. How are you helpless? You are not a petitioner. You file an appeal and nobody in the department has a copy.
That's what I find, Lordship.
We can understand that maybe in the office of the law officer it is not available. The officers don't have a copy.
I'll again check, Lordship.
They are not interested, then let it go. Why should you be worried? Twice adjourned. These 2019-18 matters for nothing.
These are the papers. What we could retrieve is this.
And for their inaction, every adjournment is costing someone also.
It's that nothing has not come, but just whatever has come is only.
No. This we are not. We have done it in a few cases.
Yes.
We are not going to start this as a practice. You get it from your officers. Everybody can't just raise their hand that we don't have anything. Then they are not interested, obviously. Let it go. It will be dismissed as not pressed.
Then give me a fortnight's time. I'll give it another try.
This is becoming very frustrating for the court.
With the state appeals, Lordship, we are also in.
Since May, you are just every day the same tune. What is new now? Has to be a limit. You have to put your house in order. You have to set things right. This can't go on forever. You can take the same plea when the case is taken up 4 years from now that I was not the law officer then. Wonderful.
Lordship, that's not, but this is.
And last day we had allow you to serve a copy to effect notice and come back. Today you are saying you don't have the brief.
See, what I got was this, Lordship. I shall send it, but without the entire brief.
See, after somebody has to take a responsibility.
That is why, Lordship.
The state doesn't have so big a cup of account that it can be.
No.
This is not we don't appreciate at all. Every other case you are saying I don't have anything, then don't have anything, then leave the matter.
And that is the problem with the state appeals, Lordship. We can't.
We are adjourning 2-3 days in every case.
Just for the records, Lordship.
It is frustrating the court proceedings. At the same time, it is costing someone some money. It's not just like that.
It's some appeals we are getting it, but not in all.
All it is public money.
It
is at stake. If your officers are not diligent, they don't have anything, then forget about these matters.
Lordship, then Lordship will kindly adjourn it for a fortnight. I'll give you another try.
A spread list after 2 weeks.
2 weeks. Huh?
Don't write in the order. Listen.
Lordship.
I have been informed by my brother colleagues that there is a thing called Sarthak.
Yes.
All the things are available there.
But what I
before my court every day you are taking adjournment.
What I find that the state appeals are not in the Sarthak.
So who is going to set things right, madam? Not the court.
That is the problem, Lordship.
Other courts you are obtaining it from Sarthak. Here you are taking time.
I've retrieved a number of petitions from Sarthak, but not the appeals. That is the problem with the appeals filed by the state. This problem.
Your panel is of last week of
Yes,
May.
Lordship, last week of May.
Now just see.
Yes, Lordship.
How long this will go on? And in between we have adjourned all these matters at least twice.
Lordship, that's true.
So if no one is interested, then what is to be done? Please ask them to organize things. Somebody has come to swear the affidavit. They must be having a file in the office. What they have filed.
That's
How can they say we don't have anything?
Lordship, all that they've been able to give me is a copy of the application for condonation.
I know how these things work.
Lordship.
Item 28.
I put the appellate matter. This is a matter where that matter where marriage Solomon is at Mohni Baba Ashram. Solomon is at Mohni Baba Ashram, second marriage matter. This is the proceeding. She heard that matter. Mohni Baba, that is.
That second marriage was solemnized during the subsistence of the first marriage. That is why the petitioner, I am appearing on behalf of the petitioner respondent. That is why petitioner was removed from his service since 2022. And the learned single judge passed an order of reinstatement, immediate reinstatement, challenging that order, the Union of India before. Nothing was, yes.
Not set aside, but
Yes, Lordship, everything was set aside. That
allowed these.
That is why the petitioner was allowed to reinstate immediately.
Obviously, how a reinstatement without setting aside the penalty cannot be.
Single judge's order is at page
Page?
215.
No, it is the Union of India's appeal.
Yes.
Yes.
Yes. Where is the order of the learned single judge?
15. Malad, it is
Volume number, Malad? 3, Malad.
215. Starts from 215.
Let us come to the inquiry report 28/1/22. It is 28/1/22.
Inquiry report, Malad, page 158 to 161. In volume number 3.
Preliminary inquiry report is 18th January 2021. And thereafter, inquiry report in the disciplinary proceeding is 28th September 2021.
Page table, page table.
Malad, preliminary inquiry report is at page 52.
No, preliminary inquiry report means nothing. Where is the inquiry report?
Inquiry report at 314 to 3, Malad, volume
314.
314, volume 4.
314 to 314.
Just now you were saying 156.
That is preliminary report.
How that is relevant?
Yes,
After that charge memo must have been issued.
314, volume 4. Yes.
Is it also available at
28/1/22 now. 28 September 2021.
It's a preliminary. After one, ঠিক আছে।
This is not an inquiry report. This is not an inquiry report. You please read page 313.
Yes, that is not
This is the
deposition.
fact-finding inquiry after which the charge memo was framed.
Inquiry report, as per my instruction, that is 158 to 161. And then subsequent show cause notice 312 to 330. And then charge sheet 405 to 408. I have already.
Please see what is at page 83. Please just have a look. Page 83.
List of dates also submitted previously,
We are asking you, where is the inquiry report?
Inquiry. 83, page 83.
28 January 2020, page number.
Page 83,
That's what I have been saying for the last 5 minutes. 28/1/22, page 83.
These and 314, both are same.
Can't be 314. Just have a look. 314 is accompanied with the covering letter at 312. 312 is a show cause asking him on the basis of that report why a charge memo may not be served. So that is probably the fact-finding inquiry prior to issuance of a charge memo. And this is the findings of the DNR proceeding. Must have held the charge as proved.
Para 7 is statement of allegation. Page 83.
This goes on to which page? 83 is
Para 7 one. Second paragraph.
83.
Srimati Pusha Devi is the complainant as far as this second marriage and other person is concerned.
Volume 2.
First wife.
No, where is the last page of the inquiry?
202.
202.
No, it is at 109. Last page is 109. Both of you are clueless about the pages.
109 is the findings, my lord.
Of the inquiry officer. That stage ends with the findings of the inquiry officer. That is what we are asking you. So who appeared before the inquiry officer? Let us see. Who has appeared in support of the allegations?
This was the statement of the inquiry officer also possible. And in subject. T14 inquiry officer and finance officer. Cosec dimension.
PW2 is the complainant.
Wife, my lord.
PW2.
PW2, yes. Wife of the, my lord, accused person, my lord. First wife.
What is her name?
Usha Devi.
Who is PW2?
চাষিটা ব্যাপার এখান থেকে দেখুন my junior also absent mala, that is the problem. My juniors also absent mala. He is online mala.
Wife of the delinquent. Wife of the judge.
Pusha Devi. She is the, that's why we are saying PW2.
Pusha Devi is the wife.
Yes.
And also the complainant.
And PW3 is one SK Shamsuddin. What is he?
SK Samsuddin is the officer of the Metro Rail.
Officer of?
Officer of the that.
Inquiry officer.
So only three.
SK Samsuddin is the security officer.
Three witnesses only.
Security officer in Metro Railway where the delinquent was
Posted. And PW4? Sanjay Das is PW4. He is a commander of RPF. And who is Visuddhanand Giri? He is from the Mutt.
priest of that month.
Priest of. Many witnesses. 9 witnesses. So why the learned single judge has interfered with the finding? Where is the judgment of the learned single judge?
Volume 215 starts from 215.
Volume 3, mother.
Volume 3. No witnesses has admitted that the marriage was consummated. Everyone denied that the marriage was, they never seen that marriage. they don't know about the marriage. And Archana Jadhav, who is the alleged girl, she also denied that she doesn't know. She at the time of marriage, she was not present there.
But evidence is completely said that.
No,
there
Which
are-
evidence? Shows the evidence. Just shows the
That
evidence.
is their
Photograph.
register and photograph. Photograph 170.
Photograph.
Who has proved the register and photograph?
Register their ashram mala register mala.
There is no
Kali come to mala.
Which page?
Is there mala? Yes, ma'am. That is mala. Volume 2 mala.
The register is at volume 2.
Volume 2 page. Mala photograph is mala 170, 171. That ashram Moni Baba Mott.
170 and 171.
Yes, 171 and 72 also registered.
And what is the date of the alleged marriage?
Date of the arranged marriage is mala. Complaint বের কর, complaint লেখা আছে।
25th June 20.
25th June 2020.
2020.
20. আচ্ছা। 214 is the statement, my lord, of the wife, my lord, first wife. page 214, volume 3, my lord.
And wife also not seen. Wife also, when the wife was asked.
Wife is the complainant, my lord. And 498 case also, my lord, criminal case also, my lord, corroborated by the, my lord, his first wife. What are we?
You can you read page 214?
Yes, statement. Statement. Volume 3.
Can you read it? Can you read it?
Huh? To read na, wife na.
So you're relying on this statement which we cannot read.
That is not the wife statement, I think.
Just now you said
Khushbu one lady, Mara, Simoti Khushbun.
Sir, you only said this is the statement. Page 214.
No, another the main papers lying with the mala photograph and also mala the complaint of the first wife, mala. That is the main thing, mala. We are not in cognizance to take decision all the inquiry proceeding other things. First wife made complaint against his her husband, and then inquiry starts, mala. Then mala all the proceeding regarding mala preliminary and other things, mala corroborated, mala. As far as this register is concerned, mala, page 171.
Again, we are asking you, who has proved these documents?
That is,
you say that the entire story was brought home, the entire allegation was brought home because this register from the mutt was produced showing the factum of marriage corroborated by a photograph. Who has supported these two documents in the inquiry For the third time, we are asking you.
Yes, my lord. That I'll show, my lord. Actually, my junior is not come, my lord. That is the problem. He's now
Come tomorrow.
online.
Come tomorrow, not today.
আসেনি না ওনারা। মনে রাখতে পারবে? হ্যাঁ?
Call the name. No, no, it will be taken up. Don't worry. You come, please mark the documents which you rely upon and the statements which you rely upon.
Yes, I দেখে নাও তাই। দুটো একসাথে হয়ে যাবে।
Item number 29.
আচ্ছা।
Page number.
কোনটা?
ওই যে নোটটা করে সেটা কি পেপার বুকের পেজ নাম্বার?
What happened?
But removal order was challenged in a writ petition. Not removal order arising out of a disciplinary proceeding, the allegation was of demanding bribe. Now, simultaneously, a criminal proceeding was also initiated. This resulted in an acquittal. Now, the principal argument advanced before the Honorable Single Judge was the charges being similar based on same evidence, whether the acquittal order will have an impact on the disciplinary proceeding. Now, all witnesses were common except one pillion rider who had deposed in my favor in the inquiry proceeding. Now, this was, I cited Ramlal's judgment, the latest one at that point of time. This was, in the facts of the case, that was distinguished by the Honorable Single Judge by saying that not proved is not disproved. Therefore, on the thin line of distinction, the acquittal in the criminal proceedings was not found to be favoring with me insofar as the disciplinary action was concerned. Now,
you said that there is an allegation of demanding bribe. Was there any actual allegation of exchange of money?
Yes, yes, that was also.
So it is not only demanding and accepting.
Accepting. Number the charge sheet was of lack of integrity and unbecoming of.
You were posted as?
I was posted as a clerk.
What is the date of the allegation?
13th of September 2010.
And charge memo dated?
6th of May 2011.
Where is the charge memo?
In the paper book, this will be at page 115 in the first volume.
Head clerk. So on 39, he made the demand.
My lord.
On 14, he came to tender that illegal gratification,
Yes.
and it was a part of the trap. There you were apprehended. Which therefore, firstly, the CBI case was instituted, and as an offshoot, the departmental
Proceedings.
Yes. And the CBI case has resulted in your acquittal.
Acquittal. Now, please consider this vis-a-vis page 56. That's the proceeding of the criminal proceeding. That's the part of the criminal charge.
This is a charge sheet.
Yes, there's a charge sheet. And we don't have that order framing the charge.
Not relevant today.
Not relevant.
There is an acquittal that is not in dispute.
Not in dispute.
Whether the benefit will go to you or not, that
That is the sole point.
So where is the charge? This is the charge memo.
And this is the 173 section 173 report.
Yes.
And may I just place it for your lordship's consideration? The case was the right hand column.
Yes.
This case was registered on 13 September against Sri Datto, Shed Clerk, number so and so, on the allegation that on 13 September 2010, the said accused had demanded from Sri Shah, son of late Shiv Narayan Shah, of so and so place, who is a labor contractor and who provides laborers for unloading imported goods from ships or vessels to trucks or containers. And in case of export vice versa, that is unloading goods from truck to ship, an illegal gratification of rupees 9,000 and agreed to accept the same for ensuring processing of the document challans and card tickets. Investigation reveals that Sri Shah, the complainant, in his
Yes.
The complainant in his letter of complaint dated 13 September 2010 has alleged that on 13 September 2010 in the afternoon, while he was supervising the work of his laborers inside Netaji Subhash Dock number 2, Kolkata 43, the shed clerk, whose duty was to make entry and handling over card tickets or discharge certificates for stacking of goods inside the cargo shed from trucks in case of export cargo, called him, that is the complainant, and demanded a bribe of rupees 9,000 for the said work done by him, that is by the accused Sri Vishwanath Datto. Sri Datto had also threatened that if the complainant did not pay the bribe of rupees 9,000 to him, he would not process the dock challans submitted by the complainant and would also not hand over tickets or card tickets to the complainant, causing thereby delay of export cargo, for which the payment of Sri Shah would be held up. When the complainant told him that he would not pay such bribe, Sri Datto further threatened the complainant that he would submit false reports against the complainant before his superiors, which would stop the complainant from entering the dock premises. The said accused had asked the complainant to pay him the bribe money of rupees 9,000 on 14/9/2010 after 7 p.m. outside gate number 3 of Netaji Subhash Dock. As the complainant was not willing to pay the bribe, and he therefore submitted a letter of complaint addressed to SPCBI ACB, Kolkata, on 13th of September 2010 against Sri Datto, Shed Clerk, Traffic Department of Kolkata Port Trust, for taking legal action against Sri Datto. On receipt of the said complaint, the instant case was registered. Investigation reveals that a trap team was constituted to lay a trap on the said accused. Presence of 2 independent witnesses, namely so and so, was arranged on 14 September 2010 at CBI office by the investigating officer. Other CBI officers constituting the trap team also attended. The said complainant, Sri so and so, also attended CBI office on 14 September 2010. The witnesses, the complainant, and other members of trap team were introduced with each other, and the purpose of assembly was explained to all. The complaint dated 13 September 2010 was read over to the witness, and the complainant owned his signature on the said complaint. Investigation further reveals that the complainant produced GC notes of different denominations totaling rupees 9,000, Srimati Tista Haldar, SI CBI ACB Kolkata, presented a demonstration of all the members explaining significance of use of phenolphthalein powder and its chemical reaction with sodium carbonate and water. The GC notes produced by the complainant were treated with phenolphthalein powder by Srimati Tista Haldar, SI CBI, who also counted the same by holding them in her hands. Thereafter, her hands were washed in a solution of sodium carbonate and water. On doing so, the color of the solution turned pink, and the said solution was preserved in a clean bottle, duly corked, sealed, labeled, and marked as A for identification. The said GC notes were again treated with phenolphthalein powder by Srimati Haldar and kept in the left side chest pocket of the wearing shirt of the said complainant as per complainant's desire. The said complainant was instructed by the investigating officer of CBI not to touch the said 1010 bunny and give the same demand, otherwise not. The complainant was also instructed to make conversation with the said accused in a bit loud voice so that it could be audible to the other members of the trap team, including the witnesses. Sri Nag witness was asked to accompany the said complainant with a view to see the transaction and overhear the conversation, if any, between the said complainant and the said accused. This witness was also instructed to give a signal to the trap team. It goes on, please come to 61 straightway. Please come to 60, the last paragraph of 60.
Or 59?
Not 60, I was facing 60 because it's ultimately says that the accused took the money in his right hand, counted the same using both hands, and kept the same in the clutch of his left hand.
Where is this?
60 at the top. Accused took the money in his right hand, counted the same using both hands, and kept the same in the clutch of his left hand. The complainant corroborated the narration made by the shadow witness. On being instructed by the investigating officer, the said accused handed over the money which was kept in his left hand to Sri Raju. Another witness, Sri Raju witness, on being requested by IO of CBI, tallied the number of the GC notes found in the clutch of left hand of the said accused with the numbers of GC notes noted in pre-trap memorandum. The numbers tallied exactly. Investigation further reveals that the said accused was instructed not to touch anything, and for the convenience of taking the hand wash of the accused and continuing the remaining proceedings in a secured area without any unnecessary attention of the crowd or any kind of law and order problem, the entire trap team shifted to the office of the Assistant Superintendent of NS Dock 2. After reaching the said office, the bribe money recovered from the said accused was preserved in an envelope marked B. The wash of both hands of the said accused was taken separately in solution of sodium carbonate and plain water, whereupon the color of the solutions turned pink. The said pink colored solutions containing wash of both hands of the accused were preserved in separate bottles marked C and D. The office table of the accused was searched and he was arrested by CBI. The post-trap proceedings were recorded in a memorandum prepared on the spot. It was signed by witnesses, complainants, CBI officers, etc. in token of its correctness. Facsimile of the seal used during the post-trap proceedings for sealing material exhibits was also taken separately and enclosed with this memorandum duly signed by all concerned. Investigation reveals that the main duties and responsibilities of the accused were supervision of the stuffing or destuffing of goods and other related work in connection with imports or exports. Besides, he used to look after the making entry and handling over card tickets or discharge certificates for stacking of goods inside the cargo shed from trucks in case of export cargo. Investigation further reveals that Central Forensic Science Laboratory, Kolkata, had informed presence of phenolphthalein, sodium carbonate, and water in marked exhibits so and so. Investigation has thus established that the said accused Sri Das Datta had demanded, agreed to accept, and finally accepted illegal gratification of 9,000 from the said complainant by abusing his official position as a public servant and obtained undue pecuniary advantage to that extent by corrupt and illegal means, and his acts constitute offences under section 7 and 13 to read with so and so of the Prevention of Corruption Act. Hence, this charge sheet is filed against the said accused. Now, please see the list of documents, and all these documents were part of inquiry proceedings as well.
So same set of documents.
Same set of documents, and the witnesses
and
at page
Nag and Raju, these were the two persons who appeared before the inquiry also. Complainant, Nag, Raju, and the
police
members of
officers,
the trap team.
Members of the team, everybody was there. Only an additional evidence being the pillion rider,
who was accompanying the accused.
The accused. He was deposing in addition before the inquiry team. I mean,
and he, as you said, he is deposed in your favor.
In my favor.
So there was no witness in support of the, according to your case, there was no witness in support of the allegations, apart from those who had participated in the trial or who were considered in the trial.
But the list of witnesses will appear at page 65. Not I have tallied each of the witnesses' name alongside the witnesses in the disciplinary proceedings. All are same except the pillion writer. Now, not the 96.
But the inquiry proceeding did not conclude.
Concluded, yes. It resulted in removal.
Oh, so the acquittal came much later.
Acquittal came later.
What is the date of removal?
The date of removal is 2nd of March 2017.
And acquittal order?
Acquittal order is dated 29th of November 21.
So in between, you had exhausted the departmental remedies unsuccessfully.
Unsuccessful. Appeal review, then writ was pending when the acquittal order was delivered.
During pendency of the writ, acquittal order came.
Yes. No, I'm sorry. Acquittal came before the writ petition.
So probably after the acquittal, you said that I should challenge it, getting the benefit of the acquittal.
21. Taking aid of the acquittal order, I sought for review before the authority as well. Having rejected, then I filed the writ petition.
Where is that order?
Of the
reviewing authorities order?
304, volume 2. Sorry, I filed the review petition. Review order to hand.
Is it on record, the order?
No, the review order is not on record. Review petition was.
So you did not assail that order?
The review order to pass on. No review order was passed.
Oh, so the review just
kept pending. So I approached this court. The honorable single judge held that this does not have any effect in my case. Acquittal does not have any effect in my case. But I relied upon a 2014 judgment which said that even if the dismissal, the acquittal order comes later on, this will have an impact on revisiting the penalty order. And I also relied on the 2024 judgment of the Honorable Supreme Court, which has been further strengthened by the 2025 view.
So let us see the honorable. Anything you want to show?
But I just need to show the Honorable Single Judge's order.
Yes, that's what we were.
But it's in volume 3, 493.
493.
My lord, in volume 3. রিভিউটা রিজেকশন হয়েছে, হ্যাঁ সেটাই তো জজ জিজ্ঞেস করলেন। I'm slightly mistaken on fact. The reviewing authority rejected my application, which was also assailed in the writ.
What was assailed?
Reviewing authority rejected my application for review, which was also.
Where is that order? Let's see that order.
That's at page.
See, ultimately, it is a judicial review of that order.
I know. It's in the second volume, 320.
320.
Up to the penultimate paragraph, it's only the recital of facts or the carriage of proceedings. It's a single paragraph containing certain paraphrases. I have seen the petition of the ex-employee and the inquiry report and other papers.
No new fact,
No new facts.
as if the acquittal does not exist.
No, but this was predated 2020 order.
Oh, this is prior to the. Then why did you move for it? This was a review in the normal course.
In the normal course of proceeding.
Not after acquittal.
Not after acquittal. ठीक है, तो representation is. Now, please come to paragraph. Now, these are the basic facts. I need not trouble your lordship with the facts anymore. Now, please come to straightway paragraph 42 of the judgment under appeal. No, no, I'm sorry. Paragraph 26, paragraph 25, 24. But one of the grounds taken in the writ petition was that the disciplinary authority's order was unreasoned.
Not a reasoned order.
Not a reasoned order. Now, please come to the questions which have been framed by the court at page 507, down below that page. The questions to be addressed by this court are threefold at page 507. A, whether an acquittal in criminal proceedings would ipso facto have a binding effect on an employer in a disciplinary proceeding. B, what is the degree of proof to be applied in a domestic inquiry where the charges are akin to criminal proceedings, that is taking of a bribe. C, whether a disciplinary authority and appellate authority are required to give detailed reasons or any reason at all when the findings of the inquiry report are being agreed upon. So B and C are examined first, and these are decided against me by holding with reference to regulation 8A of the service regulations, which is quoted at paragraph 25. The regulation heading is action on the inquiry report. The disciplinary authority, if it is not itself the inquiring authority, may on perusal of the inquiry report and representation, if any, of the delinquent, remit the case to the inquiring authority for further inquiry and report after recording its reasons in writing, and the inquiring authority shall thereupon proceed to hold further inquiry as per rule. The disciplinary authority shall, if it disagrees with the findings of the inquiring authority on any article of charge, record its reasons for such disagreement and record its reasons, own findings on such charge, if the evidence on record is sufficient for the purpose. If the disciplinary authority, having regard to its findings on all or any of the articles of charge, is of the opinion that no penalty is called for, it may pass an order exonerating the employee concerned. If the disciplinary authority, having regard to its findings on all or any of the articles of charge, is of the opinion that any of the penalties as specified in clauses 1 to 4 of regulation 7 should be imposed on the employee, it shall, notwithstanding anything contained in regulation 9, make an order imposing such penalty. If the disciplinary authority, having regard to its findings on all or any of the articles of charge, and on the basis of the evidence adduced during the inquiry, is of the opinion that any of the penalties specified in clauses 5 to 9 of regulation 7 should be imposed on the employee, itself make an order imposing such penalty, and it shall not be necessary to give the employee any further opportunity of making representation on the penalty proposed to be imposed. The regulations conceived of two situations. One, where the disciplinary authority himself inquires into the charges against an employee. The second is where the disciplinary authority appoints an inquiry officer to look into the charges and submit a report to him. The second procedure has to be adopted by the disciplinary authority. The disciplinary authority appointed an inquiry and the presenting officer, as already indicated in the facts herein above. The inquiry officer examined 10 several witnesses produced by the management. Their evidence has been taken on record. The writ petitioner has cross-examined some of the witnesses of the port trust. After conclusion of the proceedings before the inquiry officer, both the writ petitioner and the presenting officer submitted detailed comments analyzing the evidence from their respective sides. The inquiry officer has duly considered the entire evidence of each of the 10 management witnesses in the light of the representations of the writ petitioner and the presenting officer, and has found that the petitioner was guilty beyond reasonable doubt. The inquiry officer has himself found that the test to be applied is proof beyond reasonable doubt. It is essentially based on such test. The inquiry officer found the inquiry
the petitioner guilty of the charges. In the backdrop of the above, it would be relevant to examine Regulation 8A that has been set out herein above. It appears from a plain reading of Regulation 8A that a disciplinary authority is required to give reasons when it disagrees with the findings of the inquiry officer and his report. The disciplinary authority may, on the basis of the findings of the inquiry officer, also completely exonerate a charged employee. Even if the disciplinary authority finds a minor penalty impossible based on the findings in the inquiry report, he may do so. However, where the disciplinary authority is inclined to impose penalty under Regulation 7.529, it is stipulated that the disciplinary authority may impose any such penalty without giving any further notice to the employee to make a representation against the findings of the inquiry officer. The said provision has since been diluted by the Supreme Court since after the decision of Managing Director. By the said decision, it was made mandatory for all government and public sector organizations to issue what is called a second show cause notice before imposing any punishment on an employee after receipt of an inquiry report. This has been done in the instant case. Hence, notwithstanding the liberty granted to the disciplinary authority under subclause 3 of Regulation 8A, the writ petitioner was afforded an opportunity to make a representation against the inquiry report. The question that needs to be addressed now is whether or not the disciplinary authority has given sufficient reasons for arriving at a finding of guilt and punishing the writ petition. For the aforesaid purpose, the order of the disciplinary authority is set out in its entirety. Now, please, the first paragraph is not the fact recorded. Second paragraph, initiation of proceeding. Now, it goes on like that till, my lord. Please come to 513 in the middle portion. Just after not recording the name of the employee, and whereas the said Sri Datto resumed his duty with effect from 21st of January 2016. So when the suspension was revoked, I was allowed to resume duty. And whereas inquiry officer submitted her report on 9 September 2016 holding Sri so-and-so guilty of both the charges framed against him vide memorandum even number 6th of May 2011. And whereas a copy of the inquiry officer's report with findings was forwarded to the said Sri Datto, Shed Clerk, under the cover of a notice bearing even number dated 6th of October 2016.
Where is that 6/10/16?
Yes, 6/10/16 is dated, is at page. Probably 237, I just. Volume 237, 237. Two 36/10/2016 is 237.
Sorry?
237.
237.
237. In volume 2.
Did this disciplinary authority say that he was agreeing with the findings of the inquiry officer?
Yes. You know, it's a forwarding of a copy of report.
But he did not say.
No, he didn't say.
Therefore, we asked you. He
No, he
didn't
didn't
say. He said there is 3 courses available to me. Give me a response.
To that extent, not the first limb is satisfied.
Yes.
Non-application of mind at the stage of, I mean, not holding me guilty at the stage of forwarding report.
So he neither said that it was accepted, nor he said it was rejected. He said, I have got exercised the option of further inquiry. Now the further report is submitted, you give your reply. But he does not say that I have accepted the report or anything. Or that I propose to give you a punishment. Nothing.
No, not at that stage. Now, that is still a vexed question. But there is a subsequent judgment after ECIL which says that application of mind even at that stage would not vitiate the proceeding. Because to what extent can it go? If there has to be a disagreement, there has to be some application of mind on receiving an inquiry report.
And your representation thereafter is 7/11/16.
Yes. But I was placing not page 513, not from the judgment.
Yes.
So, not 6th October 2016, the report is forwarded to me for making a submission. Not I skip over not the recital of facts. Now, please come to 514. All the 12 listed witnesses, including the 2 independent witnesses, namely so and so, were produced in the inquiry. During the course of inquiry, the listed documents were vouched by the respective witnesses before the inquiring officer. During the course of inquiry, Sri Dattu in his defense submitted a document there, but that document was not taken into consideration by the inquiring officer, as Sri Dattu did not make any attempt to produce the concerned person as a witness in the inquiry. During the course of the inquiry, the concerned witnesses, while vouching for their respective signatures on the following listed documents, namely so and so, also confirmed that the said listed documents were genuine photocopies of the original document certified as true copy of the original. Further, Sri Dattu himself has not specifically raised any point about the authenticity of any of the aforesaid listed documents. Sri Dattu has not adduced any new evidence in his written representation of 7th November 2016. The charges have been proved in the inquiry. There is no legal bar for initiating disciplinary action under the applicable rules against an employee who is already under a criminal prosecution. And whereas, on the basis of the aforesaid analysis and agreeing with the report of the inquiring officer, the undersigned holds that the charges brought against Sri Dattu, vide charge sheet memorandum bearing even number dated 6th May 2011 are proved. Further, looking at the nature of the offence, the undersigned considers that to meet the ends of justice, the said Sri Dattu deserves an appropriate punishment in the instant case to have a deterrent effect and to meet the ends of justice. Now, therefore, the undersigned passes order finally to the effect that Sri Dattu is removed from the trustee's service with immediate effect. So, now this I question to be an unreasoned order. Now, coming to the views of the Honorable Single Judge at paragraph 36. The order of the disciplinary authority at first glance may suggest that the detailed reasons and discussion of evidence before the inquiry officer have not been done. Would this by itself vitiate the order of the disciplinary authority? It is now well settled that any order passed by any quasi-judicial authority must be informed with reasons. It is equally well settled that sufficiency, details, and quantum of reasons cannot be gone into by a court of law. This court is of the view that the mandate of the regulations in question must be adhered to in the light of the dicta of Supreme Court in P.T. Grover case. Paragraph 13 is set out here in below. In view of the answer so given, it has to be now seen whether under the regulations the authorities concerned are required to give reasons for their decisions. Regulation 68(3) lays down the procedure the disciplinary authority is required to follow after it receives the proceeding of the inquiry, including the report of the inquiring officer. On careful perusal thereof, we found that only in those cases where the disciplinary authority considers it necessary to direct fresh or further inquiry or disagrees with the findings of the inquiry officer, it has to record the reasons for its such directions, but there is no such obligation if it agrees with the findings of the inquiry officer. It can therefore be legitimately inferred that when express provisions have been made in the regulations for recording reasons in only the first 2 of the 3 fact situations and not the other, there is no implied obligation also to record the reasons in case of concurrence with the findings of the inquiry officer. Even if we proceed on the basis that such an obligation is implicit, still the order of the disciplinary authority cannot be held to be bad, as on perusal thereof we find that before concurring with the findings of the inquiry officer, it has gone through the entire proceeding and applied its mind thereto. In our considered opinion, when the disciplinary authority agrees with the findings of the inquiry officer and accepts the reasons given by him in support of such findings, it is not necessary for the punishing authority to reappraise the evidence to arrive at the same findings. We are therefore unable to accept the contention of Mr. So-and-so that the order of punishment was liable to be struck down as it was a non-speaking order and did not contain any reason. It would be useful to refer to the facts of the said case. The respondent employee of the bank was charged with accepting a bribe from one Moniram and was removed from service in 1983. Charge sheet was not furnished to the employee. The proceedings in the inquiry were also not furnished to him. In the backdrop of the above, the Supreme Court in P.D. Grover case went on to examine whether a disciplinary authority is required to give detailed reasons in terms of Regulation 63 of the Bank Conduct, Discipline and Appeal Regulations. The following was held. Now that we found that the departmental proceeding cannot be faulted for purported breach of Regulation 68(2), we have next to ascertain whether the findings of the learned courts below regarding the orders of the disciplinary authority and the appellate authority can be sustained or not. Before considering them in the light of the factual contents, it will be apposite to look into the laid down law of this court regarding furnishing of reasons by the administrative authorities for its decisions. Then not S.N. Mukherjee is relied upon. It was rendered by a constitution bench of 5 judges. I skip over the quotation from S.N. Mukherjee, these are well established. Then paragraph 13. In view of the answer so given, it has to be now seen whether under the regulations the authorities concerned are required to give reasons for their decisions. Regulation 68(3) lays down the procedure the disciplinary authority is required to follow after it receives the proceedings of the inquiry, including the report of the inquiry officer. On careful perusal thereof, we find that only in those cases where the disciplinary authority considers it necessary to direct fresh or further inquiry, or disagrees with the findings of the inquiry officer, it has to record the reasons for its such directions, but there is no such obligation if it agrees with the findings of the inquiry officer. It can therefore be legitimately inferred that when express provisions have been made in the regulations for recording reasons, in only the first 2 of the 3 fact situations and not the other, there is no implied obligation also to record reasons in case of concurrence with the findings of the inquiry officer. Even if we proceed on the basis that such an obligation is implicit, still the order of the disciplinary authority cannot be held to be bad, as on perusal thereof we find that before concurring with the findings of the inquiry officer, it has gone through the entire proceeding and applied its mind thereto. In our considered opinion, when the disciplinary authority agrees with the findings of the inquiry officer and accepts the reasons given by him in support of such findings, it is not necessary for the punishing authority to reappraise the evidence to arrive at the same findings. We are therefore unable to accept the contention of Mr. Datto that the order of punishment was liable to be struck down, as it was a non-speaking order and did not contain any reason. Then the court goes on to decide as to whether appellate authority is required to give reason. That brings us to the order of the appellate authority. Under Regulation 72, the appellate authority is required to consider whether the findings recorded against the officer concerned are justified or whether the penalty is excessive or inadequate and pass appropriate orders confirming, enhancing, reducing or setting aside the penalty, or remitting the case to the authority which imposed the penalty or to any such authority with such directions as it deems fit in the circumstances of the case. The regulation also does not obligate the appellate authority to give any reasons for its order. Then paragraph 41. It would follow from the above that it is essentially the service regulations that would have to be examined to ascertain the role of a disciplinary authority in a domestic inquiry. Regulation 8A lays the scope of duties of the disciplinary authority and uses the expression its findings both in clauses 2 and 3 thereunder. Regulation 8A itself is entitled Action on the Inquiry Report. A conjoint reading of clauses 1, 2 and 3 of the Regulation 8A would indicate that the reference to its findings therein are the findings of the inquiry officer, and no detailed or any separate finding is required to be given by the disciplinary authority. The inquiry officer has analyzed the evidence on record and the submissions of the petitioner in great detail. This, however, does not mean that a disciplinary authority in a quasi-judicial proceeding could pass a one-line order stating that he agrees with the findings of the inquiry officer and issue an order of punishment. That has not happened in the instant case. The disciplinary authority in his page 3 order, in his 3-page order, has clearly stated that he has applied his mind to the entire proceedings, he has discussed the proceedings briefly, and has come to agree with the findings of the inquiry officer. The disciplinary authority has also commented upon the evidence on record to some extent. Probably this is a misreading of the order of the disciplinary authority. This is therefore not a case where the disciplinary authority has mechanically relied upon the findings of the inquiry officer. It is not for a writ court to weigh the quantum of reasons and volume of discussions required to be given or made by a disciplinary authority, when the findings of the inquiry officer in its report are sufficient and in detail, this is not a case of no evidence whatsoever against the writ petitioner. The evidence on record that has been placed meticulously and in detail by the learned counsel for the petitioner clearly and sufficiently indicates the entire chain of evidence and facts having been proved by each of the management witnesses. Each of the witnesses has stated the facts, not that there was a trap laid, then it goes on like that. And 48. This court having been very carefully and meticulously taken through the entire evidence by the counsel for the petitioner, has to inevitably conclude that the factum of the petitioner taking bribe has been proved beyond reasonable doubt. The findings of this court are based on the materials that have been brought on record in the writ petition and the supplementary affidavit filed by the writ petitioner. In the backdrop of the above, even if one were to require the disciplinary authority to give detailed reasons, such omission has been cured by a detailed discussion by the inquiry officer and the consideration of the evidence in the inquiry that has come before this court. This court also finds that the charges against the writ petitioner have been fully proved, even by applying the tests laid down in H.C. Goel and Jai Bhagawan, relied upon by the petitioner. It cannot be said that the charge against the petitioner has not been proved to the hilt. The findings of the inquiry officer and the disciplinary authority, as this court finds from the evidence brought on record, are not based on principle of preponderance of probabilities. So, that issue is answered against me. Then answer to B and C. In the backdrop of the aforesaid discussion, this court is inclined to hold that the order of the disciplinary authority is fully justified and sufficient and sustainable in law. Questions 2 and 3 are answered as above and against the writ petitioner. Then we the first question, what is the effect? On the first question, that is the effect of the findings of a criminal court on a domestic inquiry, this court finds as follows. In the case of Paul Anthony, the facts of the case must be noted in some detail. The appellant therein was charged with illegally possessing a gold ball, gold bearing. I skip over the facts. Then please come to paragraph 55.
Yes, thereafter he proceeds to record that there is no extinguishment of the charge.
There is no extinguishment of the charge at that stage. Now, paragraph
since
56,
the charge stays, therefore it can be established in the proceeding.
now that was a case where the proceedings were sought to be stayed. Disciplinary proceedings were sought to be stayed on the ground that this is based on self-same facts and evidence.
No, what we are observing is the finding of the single judge here.
Yeah.
He said there is no extinguishment of charge. It is not a case where the charges were not proved or disproved. Therefore, the action is not required to be
Now,
interfered.
please come to page 530, paragraph 68.
Yes.
There is therefore a great deal of difference between an honorable acquittal and an acquittal on the benefit of doubt. In the case of an honorable acquittal, the charge itself would stand extinguished. In the case of acquittal or benefit of a doubt, it would mean that the prosecution was not able to bring enough evidence or prove the causal connection between the crime and the accused person. In the latter case, therefore, the charge does not get extinguished. So that's how not the honorable judge not makes a distinction between an honorable acquittal and an acquittal. It is only the criminal trial that comes to an end with an acquittal with the benefit of the doubt. Hence, in such cases, the acquittal in the criminal proceedings will have no bearing on a domestic inquiry, even if the charges, the witnesses and the evidence are the same. Then not in Ramlal case, now this was what we wanted to heavily rely upon. A similar question was framed by the Supreme Court at clause 8.2 set out at paragraph 12. The question of law for consideration was set out. On the facts of the case, what is the effect of the acquittal ordered by the appellate judge in the criminal trial on the order of dismissal passed in the departmental inquiry? The distinction drawn as above is supported by the observations of the Supreme Court at paragraphs 28 and 29 of Ramlal decision, which is set out. Expressions like benefit of doubt and honorably acquitted used in judgments are not to be understood as magic incantations. A court of law will not be carried away by the mere use of such terminology. In the present case, the appellate judge has recorded that Exhibit P3, the original mark sheet, carries the date of birth of 72, and the same has also been proved by the witnesses examined on behalf of the prosecution. The conclusion that the acquittal in the criminal proceeding was after full consideration of the prosecution evidence, and that the prosecution miserably failed to prove the charge, can only be arrived at after a reading of the judgment in its entirety. The court in judicial review is obliged to examine the substance of the judgment and not to go by the form of the expression used. We are satisfied that the findings of the appellate judge in the criminal case clearly indicate that the charge against the appellant was not just not proved. In fact, the charge even stood disproved by the very prosecution evidence. As held by this court, a fact is said to be disproved when, after considering the matters before it, the court either believes that it does not exist or considers its non-existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it does not exist. That's not quoting from the Evidence Act. It follows from the above that there cannot be any straitjacket ipso facto consequence of extinguishment of a charge on a domestic inquiry consequent upon acquittal in the criminal proceeding. It must be essentially seen as to whether such acquittal was not proved or disproved. Having considered the judgment dated 29th November 2021, that's not the acquittal, of the Sessions Court in the instant case, in special case number so and so arising out of RC case number, this court is of the view that the findings of the criminal court in its entire judgment can at best indicate that the charges against the petitioner were not proved. They cannot be characterized as having been disproved or extinguished in the eyes of the reasonable and prudent man. It is therefore a case where the charge in the criminal case is neither proved nor disproved. In the backdrop of the aforesaid discussion, this court is of the view that the acquittal of the petitioner in the criminal proceedings would not negate the evidence in the inquiry and the detailed findings of the inquiry officer, which this court has very carefully been taken through by the learned counsel for the petitioner. The answer to question number A above would therefore be as and above against the petitioner. Conclusion: the inquiry report, disciplinary authorities order, and the appellate authorities order are upheld. Now, I'm not pausing here for a moment. If the disciplinary authority is not required to give reasons, if he agrees with the findings of the inquiry report, then not this probably militates against the principle of managing director. ECIL. Number two, an inquiry officer only acts as a material collecting agent of the disciplinary authority if the disciplinary authority is not the inquiring officer. That is why not a disciplinary authority gets the right to disagree. In so many cases, the inquiry officer might collect the evidence and lay the evidence before the disciplinary authority for his report or final decision.
No, but here the rule requires that he is
A report.
return a finding whether it is proved or not.
Now, my lord, if he is agreeing with that, when he is applying his mind as regards the requirement of collecting fresh evidence or further evidence, further inquiring, then not that impliedly casts a duty on the disciplinary authority to return a finding. Otherwise, not the very structure of inquiry where the disciplinary authority and inquiry officer are different. But that goes. But when the second phase of disciplinary proceeding commences with my submission to the inquiry report and there is no requirement of giving a reason to the same, apropos the findings or the materials collected at the inquiry.
So where is the conduct rule?
Huh?
See, the provision that you are reading, it is the action to be taken upon the inquiry report. What is the, let us see where that provision is.
So that's quoted in the judgment, but I once again, let's not page. Page 508. The disciplinary authority, if it is not itself the inquiring authority, may on perusal of the inquiry report and representation, if any, of the delinquent,
8A,
8 capital A, at 508.
So otherwise the rule is not here.
Yes, not in the record, but not, we have separate copies of it.
Just give us 1 minute. There's something we want to see.
It had to be
that you need not read again. We just want to see.
When it starts from 207, Lordship will find it 216. The relevant rule 8 capital.
একটা দিয়ে দিচ্ছি।
In case of acceptance, the rule does not contemplate any.
Please come to 8A2.
Yes. 1 to 4 are minor or major penalties. 1 to 4 of 7.
Regulation say one is censure, 2 is withholding of promotion, 3 is recovery of pay. Yes, it comes under the broad minor penalties act.
Minor 1 to 7.
1 to 5. 1 to 4.
What do you want? We don't know right now. Yes.
1 to 4 is minor penalties and 5 onwards is major penalties. Now please come to 8A. Not 8A, 3. I mean III first. 8A1 clause III. If the disciplinary authority having regard to its findings on all or any of the articles of charge.
That is said in every clause, even in 3 it is says its findings.
Its findings, not his lordship proceeded on the basis that its findings refers to inquiry officer's findings.
No, the disciplinary authority having regard to its
findings means the disciplinary authority.
Yes.
So not the duty to find is vested in the disciplinary authority even in terms of these regulations.
In case of an agreement, where does it talk of giving an opportunity to show cause?
Because not it says if the disciplinary authority procedure for not if the disciplinary authority having regard to its findings on all or any of the articles of charge and on the basis of the evidence that is during the inquiry is of the opinion that any of the penalties specified in clauses 5 to 9 of the regulation should be imposed on the employee, itself make an order imposing such penalty and it shall not.
Therefore, it does not talk of giving an opportunity in the case of agreement.
It only speaks of doing away with a second show cause notice.
Correct. So it says an opportunity to be given in case of disagreement or for further, but it does not talk of giving any opportunity in case of an agreement.
Of second show cause notice, a proposed punishment is not required under the regulations.
No, but it does not say to give a copy of the inquiry report at this.
But inquiry report is given, not
This rule must be prior to ECIL.
yes, it's
Judgment.
much before that.
Back then,
But
there
this
were
says
certain-
action on the inquiry report.
What is the date of the rule?
But this is a rule of 87.
It does not talk of giving a notice in the case of agreement.
Not even not ECIL requires not dispenses with a second show cause notice if the rules would permit. But that is on the quantum of punishment. But duty to give reasons or fined.
So therefore, what we wanted to see is at any stage is the disciplinary authority required to show that he has found on the basis of material in the inquiry the basis for proceeding in a particular way.
That
Whether it is at the stage of serving a copy of the inquiry report or it is thereafter. Or that is not required at all. Whatever the inquiry officer has held, he will just say that yes, I agree and pass the punishment.
We have to read it, natural justice into the rules to uphold its primacy.
Assigning of reasons.
Otherwise, not the user of the expression if it disagrees with the findings. Not
in every subclause it says on its own finding. Having regard to its own finding. Its finding.
This finding is application of mind on the evidence laid before him. And this its finding, this expression its finding is not at all referable to an inquiry officer's finding.
But you did not challenge these findings till such time an acquittal took place.
Not up to the review, I had exhausted my remedy, then filed the writ petition with the aid of that acquittal order.
So what is the gap between the review order and the acquittal?
1 year.
1 year. So therefore, you accepted the findings only till such time the acquittal took place. Once the acquittal occurred, then only you approach the court.
So, note the interpretation of the rule apropos the requirement or the duty to give reasons is probably
Recording of findings at least is mandatory.
Otherwise, paraphrasing does not satisfy the requirement of natural justice. Now, please recollect those lines of cases. If I have to prefer an appeal, I must know the reasons what had weighed with the mind of the original authority. Otherwise, I can't take grounds for preferring an appeal. This was one line of judgments. Then the duty to give reasons is inbuilt in every regulation. It has to be, otherwise not.
It is one of the principles of natural justice.
That's inbuilt. If S.N. Mukherjee has been followed, then there was no occasion to deviate from that.
Opportunity of hearing, nobody can be judged in their own cause, and assigning of reasons. The three principles.
And what the very foundation of an inquiry officer's role is that he is acting as a material collecting agent of the disciplinary authority, nothing beyond that.
No, he conducts a trial. He is in fact acting in a quasi-judicial capacity, deciding the charge with reference to the material before him. He is doing a very meticulous exercise. He is examining the witnesses and then submitting a report. It is not just collection of material is at the pre-charge memo stage.
Suppose there may be cases where the authority may not require the filing of report before it. There are so many cases. I may delegate my authority to collect evidence and place it before me before I find whether he is guilty or not.
No, but here it is not a case.
That is not that case.
He was given the charge of conducting the inquiry.
The law says
he has given a report saying that the charges are proved. He has relied upon material and evidence before the inquiry officer.
But not in one paraphrasing statement, he says that I have considered and find you guilty. And I agree with the inquiry officer. And this has been upheld. So the duty to give reasons or
very well understood.
That was my first point. The second point not was with regard to the effect of acquittal.
Yes.
Now, my lord, if the distinction had to be made between disproved and not proved, then there ought to have been a reconciliation of the judgment in the trial, or some consideration of the judgment in the proceedings, in the other proceeding.
No, the judgment came much later. How it could have
No,
been
before the writ court. His lordship has made has said that this has not extinguished the departmental charge. The acquittal has not distinguished the departmental charge, because there is a difference between disproved and not proved.
The findings of the trial court have not been considered.
No. There is in the entire length of the judgment, which runs into probably 80 paragraphs, your lordships will not be pleased to find that there is any reference to the observation or not the findings of the trial court.
Yes. Then that's all. Then we'll see the judgments.
Well, we can proceed with the judgments. We had relied upon. I just need to show to your lordship only 2 pages from the judgment of the trial court.
Yes, yes.
That's at page 96.
Huh?
Page 96 in the first volume.
Volume 1. No, so first thing is that the findings of the trial court was never considered by any of the authorities, either disciplinary authority or the reviewing authority or the appellate authority.
Those were all antedated.
All are prior to the acquittal. '96.
Yes, it begins at 96. Lordship may come to page 98, almost at the bottom of that page, paragraph number 4, points for consideration. The points for consideration whether the prosecution has been able to prove the charges against the accused. Then not all the witnesses are named. Please have a cursory glance at the names of the witnesses. Utpal Sinha Mukhopadhyay, Tista Haldar, Ajay Kumar Shah, Piyush Nag, Raju, Shumanto Raichodhuri, Surojit Patro, Shubhendu Ganguly, Sukumar Sardar, Prabhas Chandra Pal. All.
Yes.
Then please have a look at a cursory glance at the documents exhibited at the trial, and all those documents which find place at that report of the inquiry officer. Then the decision with reasons come under paragraph 6. Now, Lordship may straightway come to page 101, paragraph B, the moot question. The sentence begins with the words, the moot question to be decided in this case. Not the moot question to be decided in this case, it's 101. Paragraph D at the top. 101, paragraph D, the third line from the top of that page.
Yes.
The moot question to be decided in this case is whether the prosecution has been able to prove demand, acceptance and recovery of illegal gratification in view of section 7 of the Act. But section 7 is quoted. Now, please
No,
come
in
to
fact,
paragraph
the court proceeded to hold the allegation itself baseless.
Yes. I'm grateful to
The
your
court has said in so many words that section 7 allegation is baseless.
I'm grateful to your lordship, and I was just showing that how the evidence has been considered, how it has been analyzed, and the proof was beyond all reasonable doubt.
Regarding 13, it says ingredients could not be established. Regarding 7, it says baseless.
Baseless.
This is the finding of the court.
So it's not a question of the prosecution not being able to prove the allegations because of certain lacuna in the process of investigation or a collection of evidence. But paragraph E onwards, the court goes on to answer the question. The prosecution has to prove the case beyond all reasonable doubts. Now let us find out how far the prosecution has been able to prove its allegation against the accused person. But on scanning the entire evidence, all witnesses being common apropos the disciplinary proceedings, each witness's evidence is scanned. Now please come to 106. But paragraph I on that page. Besides the aforesaid, I'm sorry.
Yes, we have got it.
Besides the aforesaid witnesses, the prosecution also examined PW2, namely Mukhopadhyay, who is the junior scientific officer of CFSL and prepared the report, and opined that he found phenolphthalein and sodium carbonate and water in all the solutions of tested bottles. In cross-examination, he deposed that in the labels of those bottles, no pink-colored stains could be found. PW7 is an employee of KOPT who made over the photocopies of some documents relating to KM Syndicate. Patro and Sardar are also employees of KOPT who proved that on 14 September 2010, the accused attended the office.
The label of the bottles, no pink stain could be found.
Yes.
How is that important?
Because that in the labels of those bottles, no pink-colored stains could be found.
So pink-colored stain was to be found in the notes, not in the bottles.
Yes, no, even the label ought to have found that stain. So these were fresh labeling made. Another vital, please see the last 3 lines on that page 106. Another vital aspect is to be mentioned here. Most of the prosecution witnesses admitted about the existence of another person, namely Vishwanath Chakraborty at the PO, place of occurrence.
He was the pillion.
PW4 deposed that accused Datto accompanied Sri Chakraborty appeared at the PO on 14 September 2010 at 8:15 p.m. by riding a motorcycle. The other witnesses also corroborated the said fact. The IO in cross-examination deposed that Sri Chakraborty was office colleague and of the accused. He deposed that when Chakraborty was returning home from NS dock, then the accused was also returning by his motorcycle. He admitted that the accused on request of the said Chakraborty had agreed to give him lift and the said Chakraborty sat on the motorcycle as pillion rider. Thus, it is true that the accused did not call Sri Chakraborty, but the latter with his own volition accompanied the accused. It is the case of prosecution that alleged bribe was accepted by the accused person in presence of the said Chakraborty. Learned Defence Counsel referred decision at so and so, wherein the Honourable Court was pleased to comment. It is impossible to believe that the accused would create evidence against himself. In normal course, this never happens. In the instant case, it is hardly believable that the accused Sri Datto would have carried Sri Chakraborty by his motorcycle to the PO to demand and accept the bribe from the complainant in order to create evidence against himself. Under such circumstances, said Chakraborty appears to be an important witness for this case. But surprising enough, the said chance witness, who could have specific knowledge about the alleged incident, was not examined by the prosecution. Such vital omission from
you said he was there in the inquiry.
Disciplinary proceeding inquiry.
That is the only thing.
He said that he has not seen me taking any bribe.
Yes, other matters now it will not be taken up. 4 o'clock. Yes.
2014 টা দেখাবো, full scene টা দেখাবো, 2014 টা দেখাবো। I have handed up a compilation to your lordship.
Okay, give this back. Give back.
The same compilation where the rules were enclosed.
Yes, we are giving it back to you.
No, please take that. No, the judgments,
Same compilations, the judgment.
it's a compilation of judgments as well.
Lordship, kindly follow the index.
Should I first rely upon serial number?
Serial?
Serial number 2022. Not serial page number 2, 2022 SCC online SC 1140. No. Please come to 162, running page 162.
Twenty 22 SCC online 1140.
Fine. But this is what not the Honorable Singh was considering. Honorable Single Judge was considering.
Who's seeing? We have had the occasion of seeing this.
This is quite a cited judgment, but not only to.
Which paragraph? Anyway, show us. We don't want to stop.
Relied upon 14 to 18.
We don't want to stop you unnecessarily.
2022 SCC online. He's come to paragraph 16, but he was dismissed, then acquittal. Thereafter, he filed a writ petition challenging the dismissal from service at 165.
Yes.
The writ petition was dismissed, but later on an appeal before a division bench, the order of the learned single judge was set aside, and it was ordered that since the constable by that time had been acquitted in the criminal court, he is liable to be reinstated in service. He was liable to be reinstated in service, and since by that time he had retired from service, he was to be treated in service with directions that he be given back wages and pension. The court, while deciding the appeal filed by the Union of India, came to the conclusion that the grounds which weighed with the High Court were specious, and merely because the employee was acquitted by the criminal court, it does not mean ipso facto that he is entitled to be reinstated in service, since he was dismissed from service after facing a disciplinary proceeding. The reason being that the disciplinary proceedings are governed by a different standard of proof, which are different from what is applied in a criminal proceeding. Not skipping over the criminal misconduct and so, I straightway come to page paragraph 20, which is at page 168.
Actually, in that case, the acquittal was giving the benefit of doubt.
That was a case of benefit of doubt, a lesser standard case.
Yes.
But I put my case at a higher pedestal.
Here he has held that it is there is no baseless.
Basis.
It is baseless, and that there is no ingredient to establish 13. Yes. Yes.
But paragraph 20, which was relied upon by his lordship. This is at page 168 of the compilation. It is true that this court, apart from the case of Paul Anthony, has in a few cases not interfered with the reinstatement of an employee who was dismissed as a result of disciplinary proceedings and was only reinstated in service because of his acquittal in criminal proceedings. But again, the reasons which weighed with the court in such cases were that in almost in all such cases, the acquittal was an honorable acquittal and not an acquittal on a technicality or an acquittal given because of benefit of doubt. Now, that's a distinguishing feature. বল মামলা চলছে যেটা মামলাটা একটা দিও দেওয়া আছে
Compilation আছে
Ramlal is at page 57, 2024 1 SCC 175. 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 paragraph 9 for the paragraph 9 first. Paragraph 10. We have examined both the questions independently, the questions for consideration being whether the dismissal of the appellant from service pursuant to departmental inquiry was justified. 2. On the facts of the case, what is the effect of acquittal ordered by the appellate judge in criminal trial on the order of the dismissal passed being the disciplinary inquiry. We have examined both the questions independently. We are conscious of the fact that a writ court's power to review the order of the disciplinary authority is very limited. The scope of inquiry is only to not I need not trouble your lordship. Then paragraph 12 and 14. No? Yes, paragraph 12 is important. However, if the charges in the departmental inquiry and the criminal court are identical or similar, and if the evidence, witnesses, and circumstances are one and the same, then the matter acquires a different dimension. If the court in judicial review concludes that the acquittal in the criminal proceeding was after full consideration of the prosecution evidence, and that the prosecution miserably failed to prove the charge, the court in judicial review can grant redress in certain circumstances. The court will be entitled to exercise its discretion and grant relief. If it concludes that allowing the findings in the disciplinary proceedings to stand will be unjust, unfair, and oppressive, each case will turn on its own facts. Then 14. That 14 was not for the purpose of discussion of facts. Paragraph 24. 23 and 24. At 66. It is very clear that relevant and material evidence being the deposition of PW5, the mark sheet of 8th class of the appellant, and the original mark sheet independently marked as D3 by the defense have been completely left out in the discussion and consideration. Inference has been drawn about the proof of the charges by ignoring crucial, relevant, and material evidence which had come on record. The evidence of PW5 and the mark sheet enclosed in the documents annexed to the charge sheet and the original mark sheet, marked as D3, were materials having a direct bearing on the charge. The disciplinary authority has merely reiterated the reasoning in the inquiry report. Equally, so are the findings of the appellate authority. It is well settled that if the findings of the disciplinary authorities are arrived at after ignoring the relevant material, the court in judicial review can interfere. It is only to satisfy ourselves to this extent that we have scrutinized the material to see as to what was reflected in the record. We are satisfied that the disciplinary proceedings are vitiated and deserve to be quashed. Not this impliesly supports the argument that not a disciplinary authority has a duty to analyze the evidence as well independently. In this scenario, we are inclined to accept the explanation given by the appellant that overwriting in the application form was only due to correction of an inadvertent error, as long as the original mark sheet reflected in the date of birth was so and so, and there is no correction or manipulation in the document, the appellant cannot be penalized. Effect of acquittal in the criminal proceeding, question number 2. With this above background, if we examine the criminal proceedings, the following factual position emerges. Then not the court goes on to not compare the two proceedings. Then please come to paragraph 28.
27 এই জায়গাটা নোট আউট
No, I'm sorry. Paragraph 27 at page 67. What is important to notice is that the appellate judge has clearly recorded that in the document, that is original mark sheet of the 8th standard, the date of birth was clearly shown as 1972, and the other documents produced by the prosecution were either letters or a duplicate mark sheet. No doubt the appellate judge says that it becomes doubtful whether the date of birth was 1974 and that the accused was entitled to receive its benefit. However, what we are supposed to see is the substance of the judgment. A reading of the entire judgment clearly indicates that the appellant was acquitted after full consideration of the prosecution evidence and after noticing that the prosecution has miserably failed to prove the charge.
সিঙ্গেল কি করে শুধু 28 মধ্যে দেখে চলে গেল
Expressions like benefit of doubt and honorably acquitted used in judgments are not to be understood as magic incantations. A court of law will not be carried away by the mere use of such terminology. In the present case, the appellate judge has mentioned so and so, but not what is to be really tested is the substance of the judgment and a wholesome reading of the judgment if it leads to a conclusion that the entire prosecution evidence has been analyzed, leading to an acquittal. That's the test to be applied.
business after considering intelligence. এখানে একটা করি না একটা নিজেই বলছি
In that context, not paragraph 29 reads on that we are satisfied that the findings of the appellate judge in the criminal case clearly indicate that the charge against the appellant was not just not proved. In fact, the charge even stood disproved by the very prosecution evidence. As held by this court, a fact is said to be disproved when, after considering the matters before it, the court either believes that it does not exist or considers not. This is quoting from the evidence.
This was recorded in the order also.
Now, 30 gives the relief. We are additionally satisfied that in the teeth of the finding of the appellate judge, the disciplinary proceedings and the orders passed thereon cannot be allowed to stand. The charges were not just similar but identical, and the evidence, witnesses, and circumstances were all the same. This is a case where, in exercise of our discretion, we quash the orders of disciplinary authority and the appellate authority, as allowing them to stand will be unjust, unfair, and oppressive. This is very similar to the situation in DM. So, we have two tests, as laid down in paragraph 27 and 30. SCC online SC 890. 2025 SCC online SC 890. Not paragraph 25. The issues for determination that emerge for decision are. But that's not in the compilation, it's separate. Paragraph 25. Lordships may straightway come to paragraph 25, that is print page number 8. May I please note the issues for consideration. The issues for determination that emerge for decision are whether due process was followed in dismissing the appellant from service and whether his dismissal from service is justified on the facts and in the circumstances that have unfolded before us, whether in the light of the facts, evidence, witnesses, and circumstances of the case, the charges in the criminal proceedings are substantially identical to those in the departmental proceedings, such that an acquittal in the criminal case would render the findings in the disciplinary proceedings vulnerable. Whether the impugned judgment which allowed the appeal of the respondents and dismissed the reputation of the appellant deserves to be appealed. At the outset, it is pertinent to note that considering the nature of arguments advanced which required ascertaining facts by looking into the records of inquiry, which are not on record, we had required the respondent, we had to so and so, 114G of Evidence Act. Then we regretfully record that neither has the department, I skip over that. Now please take paragraph 46, which is issue number 2. The aforesaid discussion on the first issue seals the fate of the respondents. However, since arguments were advanced in respect of this issue too, we propose to briefly answer the same. While an acquittal in a criminal case does not automatically entitle the accused to have an order of setting aside of his dismissal from public service following disciplinary proceedings, it is well established that when the charges, evidence, witnesses, and circumstances in both the departmental inquiry and the criminal proceedings are identical or substantially similar, the situation assumes a different context. In such cases, upholding the findings in the disciplinary proceedings would be unjust, unfair, and oppressive. This is a position settled by the GM tank.
This is, we have just read this. The same thing is being reiterated.
It's not only one thing, not in the other judgment of 2024, the Honorable Supreme Court would say, had held that this would once again depend on fact situation. But not in paragraph 47, the court straightway says that it would be otherwise oppressive if the evidence and the witnesses match and the charges match. To assess the degree of similarity between the charges, not paragraph 48, evidence, witnesses, and circumstances in the disciplinary and criminal proceedings, it is indeed crucial to review the materials placed before the court where such an issue arises. However, we regret absence of the departmental file has disabled from doing the same. Notwithstanding the above, a plain reading of the materials available on record only reveals that charge number 1 in the disciplinary proceeding closely resembled the allegations in the criminal proceedings. In fact, the disciplinary proceedings were initiated based on the written complaint of the informant. The judgment acquitting the appellant reveals that the prosecution miserably failed to prove its case beyond reasonable doubt, as both the informant and PW2 refused to identify the appellant in court. This discussion confirms that the appellant's acquittal was based not on mere technicalities. In Ramlal, this court held that terms like benefit of doubt or honorably acquitted should not be treated as formalities. This court's duty is to focus on the substance of the judgment rather than the terminology used. But that's the same test, not reiterated with approval.
It is reiterated, same test.
But if on a cursory reading of the trial court's judgment, not vis-a-vis the multiply করে লাভ কি আছে? না না if a cursory comparison of the two proceedings not and the judgment in the criminal trial not gives an indication that the entire prosecution case had been scanned, analyzed, and then a finding has been returned that the charges could not be proved. But the observation in this judgment is baseless. Then there cannot be any second thought in my most respectful submission that I am entitled to the benefit of this judgment. These are my submissions. No. These are my submissions. Mr. Bose.
Pillar 97, my learned senior friend has shown your lordship's kind attention. 197 of the volume. His understanding of the judgment of acquittal. I start reading from page 106. Last few paragraphs. The last one, the evidence shows that there are lots of contradictions on material particulars, and accordingly in such cases, the court has to find corroborated evidence. Yes. Corroborated evidence by independent witnesses. Besides the aforesaid witnesses, the prosecution also examined PW such and such, who is junior scientific officer of CFSL, and prepared a report and opined that he found such and such and sodium carbonate and water in the solution of tested bottles. In cross-examination, he deposed that in the levels of those bottles, no pink color stains could be found. PW7 such and such, an employee of KAPT who made over photocopies of some documents relating to claims indicate such and such. For PW8 Surajit Patra Shukumar, an employee who proved that on 14 September 2010, the accused attended office PW11, Sri Prabhas Chandra Pal is the second IO of this case, who after conclusion of the investigation submitted charge sheet, the accused. In cross-examination admitted that it is not possible for him to say what actually happened on 14/9/2010 and PO and was not present there. Another vital aspect is to be mentioned here that most of the prosecution witnesses admitted about the existence of another person, Vishnu Chakraborty, at that accused Vishnu Chakraborty appeared at the such and such date. The other witnesses also corroborated the same fact. The other such and such in Vishnu Chakraborty was the accused. He knows that when Vishnu Chakraborty was returning from also returning his motorcycle, he admitted the request of the Vishnu Chakraborty to give him Vishnu Chakraborty sat on the motorcycle as per the indicted. Thus, it is true that the accused Vishnu Chakraborty accompanied the accused. It is a case of the prosecution that the was accepted by the accused person in presence of the said Vishnu Chakraborty and the counsel decision passed by such and such decided the honor court dismissed to comment. It is absolutely beyond the accused against himself. In instantly it is hardly believable that the accused Vishnu Datta would have carried said Vishnu Chakraborty motorcycle to the accept the blow from the complainant in order to create evidence against himself. Under such circumstances, Vishnu Chakraborty appears to be an important witness for this case. But surprisingly enough, the said chance witness who could have specific knowledge of the incident was not present in the prosecution. Such vital omission from the side of the prosecution will definitely be shaped by the presumption under Section 114G of the Indian Evidence Act. Now, the court has recorded the implements of Section 13. The accused Vishnu Datta is found to be a public servant. The sanction under Section 19 of the PC Act, though valid. The prosecution failed to prove as to such and such act. The allegation for such and such is also found to be baseless. Thus, prosecution was unable to prove the charges against the accused without a shadow of reasonable doubt. The accused person deserves to recall the prosecution phase. Now, such and such found not guilty under the such and such. So, the favor on the part of the prosecution to prove the charges, my lord, is synonymous with the concept of honorable acquittal. If it is an honorable acquittal, then what is the ramification? 18, my lord, the disciplinary proceeding concluded, my lord, its findings, and 21, my lord, this gentleman was acquitted. So there was no occasion for the disciplinary authority. Yes. Now during after the disciplinary proceeding, my lord, it is needless to mention that it commences with the issuance of a charge sheet. But during the pendency of the proceeding, the gentleman came and approached this honorable court by way of a writ petition. Now, earlier. And appeal also preferred. The appeal court confirmed what the order of page 344.
What did he approach for? The charge memo?
Yes, no.
That, my lord, with the leave of my senior, he approached at that point of time to stay the proceedings in a similar. I could say no, very let it be proceeded.
No, but because the normal is that correctness of the charges at this stage, the court cannot go into this. The appeal court also affirmed.
He must have come saying that I will prejudice in the criminal trial, therefore you stay this.
You stay, that is, the
court. The law is by now it has evolved. Both will proceed simultaneously.
Accede to such request.
Yes.
Appeal court also will. The question here is, Millard, that my learned esteemed senior friend has taken my lord's kind attention. Millard, the compilation with not with us. So, Millard, if I can, Millard, the judgment he has shown, the paragraph 9, 12, 14. Give. No, Millard, if I may take his, Millard, this, I can, Millard, the first judgment, 2025 SCC.
He has relied on 3 judgments. One is at serial.
He has relied on
this one.
63 SCC.
Ramlal, he has relied upon
2024 1 SCC.
Yes.
Ramlal.
And then
5 SCC.
Maharana Singh, Full Singh,
Maharana Pratap Singh, and
Lordships are correct.
And
Full Singh, Ramlal, and Maharana
Pratap. 3 judges.
Except Maharana Pratap, rest were there. Well, 2 relied by us, and Mr. Majumdar said Full Singh, since learned single judge, Millard, consider.
Let him read if he wants.
Yes. Now, Millard, I will show a judgment tomorrow, Millard, that what is the honorable acquittal and what is the ramification. Now, Millard, my learned senior friend has read, Millard, from this judgment, 2025 SCC online, 9, 12, 14.
No, that is on the acquittal aspect.
Acquittal aspect.
What we are, another aspect which was raised is that disciplinary authority, according to the petitioner, the disciplinary authority's actions suffer from non-application of mind because he has not considered the report at all. he has not given any finding in respect of the inquiry report, even if it is not required to be done at the stage of show cause. The final order imposing punishment also, there is no recording of conclusions by the disciplinary authority with reference to the charges.
Milord, let me, Milord, first, Milord, deal with this, Milord. Then, Milord, I will, if I may allow, I will deal with that, Milord. Milord, here, Milord, the issues that were framed, kindly sees 9.
So if you want to continue, then you continue on it.
I want to continue.
Then you will continue. You tell us when you want to continue.
Next Monday, Friday. Milord, tomorrow I will go to Benares, Milord, for 2 days. In the evening also.
Next Monday is what date?
Next Monday.
27, Milord.
27. Your Lordship has fixed another matter, that is perhaps.
2 already fixed on Monday, sorry.
28. Or Friday, 24.
Friday है? No. Friday. Yes. The learned senior advocate for the appellant has taken the court through the judgment of the learned single judge as well as the order of acquittal, whereby the present